One. They're on a little early. Webster County Jail, are you there? We had you scheduled for 10.
Yes, sir.
I see you on there, so we'll go ahead and take you now. If you got Tiffany Hitson there.
Yes, sir, I do.
Okay.
Over here, Risby. There you go. You're right there.
Okay.
Sorry. There you go.
This is Monroe Circuit Court, criminal action number 22 CR 0026, Commonwealth of Kentucky versus Tiffany Marie Hitson. Are you Tiffany Marie Hitson?
Yes, sir.
Okay, were you born in 1994?
Yes, sir.
Last four digits of your social security number 5920.
Yes, sir.
Okay, you've been indicted in Monroe County, and I understand that you didn't want to fill out an affidavit to get a public defender appointed. Is that correct?
No.
Okay. So do you have any assets or anything?
No, sir.
Okay. And you're a state prisoner? Well, I'm going to go ahead and appoint the Office of Public Advocacy to represent you. Are they here? Okay. Okay. This is your attorney on there who's going to represent you. You have the right to remain silent. Okay. The grand jury returned an indictment charging you with receiving stolen property in violation of KRS 514-110, over $10,000, a Class C felony, public intoxication. You understand what those charges are?
Yes, sir.
I'm going to give a copy of the indictment to your public advocate here. Counsel, do you acknowledge the identity of your client? Waive formal reading and arraignment, interplay of not guilty, reserving all pretrial motions.
Yes, sir.
Ma'am, I'm signing a reciprocal discovery order here that says the Commonwealth will give your attorney the evidence to prepare for your defense. She'll be in contact with you. When is the negotiation day that we have coming here?
It's the big building up here.
Okay, we'll have a negotiation day on October 7th at 9 a.m. and the next court date is October the 20th. It will be your next appearance, and they'll be in contact with you to see if you need to be transported up here for the negotiation day or determine how we can affect that. Okay. Well, thank you. Thank you very much.
Thank you.
And Webster County, thank you for your cooperation. You may be excused.
Bailey.
Go ahead, can you take them off? Okay. Commonwealth versus Michael Austin. Michael Austin, are you here? Commonwealth versus Michael Austin, 21 CR 0078. Are you Michael Austin?
Yes.
Born in 1966?
Yes.
Last four digits of your social security number 7734.
Yes.
You're here today for purpose of arraignment. You're represented by counsel. You have the right to remain silent. The grand jury of Monroe County has returned an indictment charging you with marijuana cultivation, trafficking in marijuana, possession of controlled substance, and possession of drug paraphernalia. Counsel, do you acknowledge the identity of Mr. Austin, received indictment, waive formal reading and arraignment, interplea of not guilty, reserving all pretrial motions? October 7th at 9 a.m., Mr. Austin, you'll be here for negotiations. October 20th is your next court date. I'm signing a reciprocal discovery order. The Commonwealth has just given you certain information there to help you prepare for your defense, okay?
With the pretty bad foot problems and You need to get.
I don't know. I really don't know anything about the case. What does the Commonwealth have to say about the case?
The issue right there, that's an arraignment.
Foot monitor. They want him off his foot monitor.
Oh, he's an NCIC graduate. I think the monitor would be.
Okay, you can schedule a hearing. Okay. Mark Brown. I can't hear you.
The way it's going today.
I,
But that's, I know.
nobody told Mr. Brown about this. Is that what you're saying? Who from who this person from probation parole have a name? Mr. Collins, what do you know about this? You know?
Your Honor, she just informed me that she had spoken with him and she said she's on her way here.
Okay, well, I'll pass over to Dr. Ralph Carpenter. Ralph Carpenter. Could you get my briefcase there? Yeah. Ralph Carpenter. There's a letter here to whom it may concern. Ralph Carpenter, and gives his date of birth, 8/24, has an appointment at Medical Laser Center and Rural Family Practice in Berea, Kentucky today.
What's it say about?
Has an appointment. Issue an arrest warrant. Be held without bond. Shannon Clarkson. Okay. Active warrant, NCIC.
He's a low guy, Your Honor, and he's playing a good game of hide and seek right now. We'll catch him there. I think it'd be a waste of time for the fiancé.
Okay. Change the condition of his bond to be without bond for Belgium, FTA. Without bond, FTA. James Forrest.
I make a motion to return the property as a victim to the.
Okay. Do y'all have the order over there? You have the order.
It's the same motion, please, for Joe.
I've got it here. Sadie Fuentes. It says Fuentes here. I don't know.
Sadie Gonzalez Fuentes on the docket.
Okay, Sadie Gonzalez Fuentes, yeah. If you raise your right hand, please do solemnly swear or affirm that you are authorized to do translation services in the courts of Commonwealth of Kentucky, and will truly and faithfully execute those duties in this court.
I do.
Thank you very much. This is Commonwealth of Kentucky versus Sadie Gonzalez Fuentes. Is that how you say the last name? Okay. I've reviewed your application for financial appointment of your financial statement concerning appointment of a public defender. And I will sign that.
So you were approving an attorney firm?
Yes, this is her attorney.
Thank you.
You're here today for the purpose of arraignment. That means I will read the charges the grand jury has against you. The grand jury of Monroe County has returned an indictment charging you with trafficking and controlled substance. First degree. Also, criminal trespass, first degree, and public intoxication. Counselor, do you acknowledge the identity of your client? Waive formal reading and arraignment. Enter a plea of not guilty on her behalf, reserving all pretrial motions. You do that? We'll have a negotiation day on October 7th at 9 a.m. And the next court date is October 20th. Now, Ms. Gonzalez Fuentes, do you understand any English at all? Can you understand me a little bit? Okay. Well, we'll probably need an appointment for her to have a translator at the negotiation day too, okay? Okay, thank you very much. Miles Geralds. Good morning, Your Honor. Hello, my friends. Have you lost something here? Can I help you? That's good. Commonwealth of Kentucky versus Miles Geralds, 22 CR 0060. Are you Miles Geralds? What's your year of birth, Mr. Geralds? What's your year of birth? Your year of birth is what? Right, okay. The last 4 digits of your social security number are? You're here today for a pretrial conference. What do you have, Mr. Bell?
No, we had the negotiation today, we'll wait on the Lab and also Discovery, which they provided, I think, most of it that day.
October, will you have that by October the 20th? You want to hear on the negotiation day? Negotiation day is October 7th at 9 a.m., sir. And your next court date is October 20th, and both of those are conditions of your bond, okay? Thank you. Billy Graves. Commonwealth versus Billy Graves. 22 CR 00070. Are you Billy Graves? Born in 1973? Okay. The last four digits of social security number are what? Okay, I've looked at your financial statement here. And I'm going to appoint you a public advocate, but I'm going to assess you a $500 fee on that. Still a pretty good deal to get an attorney for $500, but you look like to me that you're near the line, but just a little bit over it. You should have that paid within 30 days of today. I'm gonna say on by the 19th, okay, because you're supposed to be back here by the 20th. You're here today for the purpose of arraignment. You have a right to remain silent. I'm gonna read the charges that have been placed against you. If you have any questions, step back and ask your attorney. The grand jury of Monroe County has returned an indictment charging you with operating a motor vehicle with one headlight, failure to signal, expired plates, no or expired plates, failure to maintain insurance, and possession of controlled substance. You understand those charges? Counselor, you acknowledge Mr. Graves' identity, you received indictment, waive formal reading and arraignment, interplay of not guilty, reserving all pretrial motions. I'm signing a reciprocal discovery order here, Mr. Graves. The Commonwealth has given you certain information to your attorney to help you prepare for your defense. You'll be back here on October the 7th at 9 a.m. for negotiation on your case, and the next court date is October the 20th. Both of those are conditioned to your bond. Do you understand that? Okay, thank you very much. Whitney Graves for review, it says. Okay. I'll sign it. Do we have the order here? I guess. Ms. Megan, you'll just make sure we get it right. Yeah, okay. Jose Hernandez. Do what? Okay, thank you. This says there's an active warrant out for Mr. Hernandez.
We were here on negotiation day, and I looked at the indictment. I didn't see a felony. I discussed that with Commonwealth. I believe they're in agreement with that. And I believe they were going to agree with that to allow him to stay out on the original district court bond. No, I said that. I believe they're going to agree to allow him to stay out on the district court bond. Yes,
Well, I still don't understand. Is there a felony indictment? He has to be arraigned.
The felony is that.
Please, forward, I would ask you, we'll get this resolved.
I'm gonna arraign him. I'm gonna arraign him and get him in front of the court, and he has to be processed at some juncture. Do what? And I will go ahead and leave his bond the same since he didn't show up today. But I have to arraign him and get him processed. He have to be photographed and that sort of thing. So somebody needs to explain to him that he's not like going into a deep hole somewhere. Okay. He's not going into a deep hole or anything. He's not going to jail right now. He's just going to be processed. The grand jury of Monroe County has returned an indictment charging Mr. Hernandez with speeding, reckless driving, resisting arrest, menacing, terroristic threatening 2 degrees, wanton endangerment in the 2nd degree, possession of marijuana, disorderly conduct, possession of drug paraphernalia, carrying a concealed deadly weapon.
I'm sorry, what was that?
Carrying a concealed deadly weapon and operating a motor vehicle under the influence.
Judge, I think that ain't right. The push, the terrorist threat, the second.
Do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty? Okay. The negotiation day is October 7th at 9 a.m. The next court date is October 20th.
Thank you, Judge.
Whether he's guilty of a felony or not, or whether you want to charge him with a felony, you decide, but it sounds like he had quite a night anyway, so. Angela Mendez. Are you Angela Mendez? This is 22 CR 0007. Looked at your affidavit here. I'm going to approve appointment of the public advocate. The grand jury of Monroe County has returned an indictment. How do you say it? Angela or Angela? Angela. Miss Angela Mendez of improper registration plate, expired plates or no plate. Possession of controlled substance 1st degree. You understand those charges? Counsel, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions? I'm signing a reciprocal discovery order that will allow your attorney to get certain information about your case. You shall be here on October the 7th at 9 a.m. for a negotiation day, and October the 20th for your next court appearance. And both of those are conditions of your bond. You understand that? Okay, thank you. Jeffrey Miller.
Right, Andy, for 3 months. David Roderick was on the other side. This was scheduled to be a suppression. His motion to suppress. It was originally contingent on Mr. Roderick's motion because he had a murder trial that developed. It was contingent on the Commonwealth motion on the grounds that one of our primary witnesses had been called to service in the National Guard. And we learned a few minutes ago that Mr. Roderick has received no notice that had been reset for the day. And that's where we stand.
Okay, well, let's set it for, is the case set for trial?
No, this is just a suppression of.
Well, let's,
And this is a complex motion, Your Honor, with a complex series of facts to it.
you think I can comprehend it?
Well, I suspect that you can.
It's gonna take me some time, is what you're
And
telling me.
if we go real slow,
Okay,
but what we're doing is actually we request that I think it needs to be heard on a day by itself.
okay.
And if we can find a date, the district court's calendar that would let us do it.
I'd just rather hear it on a rule day. We can set it in the afternoon after you do the civil document. That way, so we won't be, you'll have plenty of time, Mr. Broderick will have plenty of time. So let's set it on October 20th.
All right.
And at the conclusion,
That he gets notice.
that'd be good, or we can continue it again. What?
After the
2 o'clock?
2 o'clock, 1 o'clock.
2 o'clock is our confidential.
What if we have anything scheduled?
I don't know.
Well, we'll schedule it at 2 o'clock. That's our confidential docket. We'll hear the confidential docket first. And if we have one, we never know whether we're going to have a confidential docket.
All right, thank you.
Yeah. Jerry Mosby. Jerry Mosby.
We have an agreement between Mr. Mosby, he was in a care home.
I can't hear you.
Mr. Mosby had previously been in a care home where the facility was doing a mail-in report for him. The state had done audit there and told him to leave. He is now in another living facility, and I've spoken to Jesse about this. Jesse wanted to reset this a month to allow probation parole to become more involved at that facility. That's right.
So you want to set it for October or November? Which one?
Jesse and I had agreed to 1 month of cancel the probation parole. How we got to work on this. October will be fine.
October the 20th. Parker Pettit.
You know, Your Honor, when he was not directed toward me, and I'm going, I find it quite interesting.
Well, I'll try to make sure you get to queue on this thing. Okay. Do you have a plea in this case?
No, this was.
Commonwealth of Kentucky versus Parker Pettit, 20 CR 0057. Are you Parker Pettit, born in 1989? Last 4 digits, social security number 4795. Okay, we have a pretrial conference here.
This is where we wait on discovery, also that we provided most of it, I think, on the day.
I'm not aware of the discovery that have to be provided. The case was delayed, looking for body cam, but we've been told there is no body.
I had asked for body cam, I was getting discovery on the negotiation. And I believe that's what it was, both of them.
They say they got no body cam, so they're telling you.
Yes.
Did you do negotiation on the case?
Yes, sir. Right, I didn't have any discovery until I got here. All the negotiations,
Well, there was an effort that negotiation. I don't think further negotiation is gonna be any good in this case. We're not gonna throw this case away, and I'll explain to the court how we.
Yeah, if I got a position, you know, Mr. Hunter's got a position,
I won't-
it really doesn't matter that much. We'll do whatever.
Well, it's his opportunity to ex parte me without ex parte, and you can't deny him that opportunity.
He can do that.
Okay,
We simply asked them for a trial date.
it appears that I don't have my. There it is. Well, what is the charge here? Mr. Hunley, what is the charge that you're trying?
Possession of fentanyl, Your Honor.
Okay.
Right. I'm not sure that's. And a persistent felony.
What about November the 15th? Wait just a second here.
If I do have some line items and things of that nature, I hope they can get that to me expeditious, and I will count that discovery.
It should have already been stopped.
You think this can be tried in one day?
Yes.
There would probably be some motion filed prior to the trial.
Well, we have, they need to be filed for October 20th.
If I've got everything to do it,
Well, if you don't have anything to do with it, you won't know what to file. So,
yeah.
so it'd be October 20th, your motions is filed. What do you think you do not have in way of discovery, Mr. Bell?
Judge, I can't be for certain because some of it, I believe, only came in maybe yesterday, and they didn't pack it when I was up there at negotiation day, which was. But I'm gonna have something to really do it. Oh,
Okay. Well, review it closely and contact them soon enough so you can make a motion to compel on the 20th. That'd still give you considerable time before the trial, okay?
yeah,
Sure,
sure.
our records show that the lab reports and officers' reports were submitted on August 18th. So he's had it for a while.
Well, your record is like that, that's not what I'm thinking.
Well,
I don't see how that can. Anyway,
it doesn't matter. You just check, see what you have. You don't have it, call and ask them for it. If they won't give it to you, bring a motion, compel on the 20th.
Yes.
Okay, thank you. Jamie Pearson. Commonwealth versus Jamie Pearson. Are you Jamie Pearson? Were you born in 1987? What are the last four digits of your social security number? It says we're here for review. What's the Commonwealth have? Okay, so we have nothing else to do except wish him well in drug court. Work at it hard, okay? Okay, thank you very much. Bobby Pruitt.
He is in custody, Mr. Brown is representing him.
He's in custody here,
He is in the Barron.
Barron County. Okay. I'll move
That's
him
my
down
case, Judge.
to the jail docket. We're moving Bobby Pruitt down to the jail docket, which will start very shortly. Okay.
Thank you, Judge.
Jeannie Ramos. Are you Jeannie Ramos? Okay, we'll just wait just a second. Yeah, okay. Commonwealth versus Jeannie Ramos. 22 CR 0041. Are you Jeannie Ramos? Born in 1978. What are the last four digits of your social security number? We're here for a pretrial conference. And you have something you want to say, Mr. Garrett?
Yes, she said for a conference with Dr. Sidney in about 2 weeks. So we'll get that back probably for the next month now, of course, and they're very well putting something.
Okay, well, if it's in 2 weeks, let's go ahead and set her. When will you get the report? When will you get the report?
When he said it, he's gonna evaluate her within 2 to 3 weeks, could be sooner than that. I don't know when the report will come.
Well, let's set it out for October the 20th, next court appearance. There's no reason to have what do you have that you're anxious?
Just the reorder and the conference that needs to be sent to Dr. Sidney. They're into the report. I spoke with him yesterday. He's about 2 weeks out. He may be able to get through it.
Trying to see when the November rule day was. It's the 10th. Sorry. You want us to go ahead and set this for the 10th?
Yes, that'd be fine.
Sure, it'll be finished by then. And you don't know what the negotiation day is going to be in November yet? November 4th will be the negotiation day. And November the 10th will be the next court date. Okay. Aaron Southworth. Aaron Southworth. Commonwealth versus Aaron Southworth. Mr. Southworth, look at your affidavit here, and so I will appoint you a public defender, but I'm going to assess you $500. We pay by the 20th day of October, which is your court date here. You're here today for the purpose of arraignment. The grand jury of Monroe County has returned an indictment charging you with failure to signal, careless driving, possession of drug paraphernalia, and possession of controlled substance. You understand those charges? You have a negotiation day here on October 7th at 9 a.m. and your next court date's October the 20th. Bailiff? I'm signing a reciprocal discovery order here, sir. The Commonwealth will be giving your attorney information to help you prepare for your negotiation day and for your next court appearance. Negotiation day and the court appearance are both conditions of your bond, okay? Andrew Thayer. Andrew Thayer. Is he, so y'all might want to take a look at Andrew Thayer as far as the NCIC.
They have already taken.
Okay. Sherry Turner, change the condition of Mr. Thayer's bond to no bond. Okay, no bond for Mr. Thayer because he's a fugitive. Sherry Turner. Sherry Turner, the active warrant still out, has not been served. Is she a local? Have her help change the condition of her bond to no bond. David White. Commonwealth of Kentucky versus David White, 22 CR 0045, 46, and 47. Mr. White, are you David White? Are you born in 1961? Last four digits of your social security number 2049. We're here on, it says probation revocation, is that correct?
We have an agreement with Mr. Stockton. He is being reattached to the drug court program. He is accepted.
I want to know what the probation revocation is first. If you kind of include me in the circle, I don't want to interfere with your Mr. Stockton's conversation, but I like to know a little bit about what's going on sometime. I would let the Commonwealth tell me if you don't mind. Yeah.
We have discussed with that news. I think Mr. White has been using that. He thought that meant that I could move in touch with. Say you have a drug problem, go to the honest whether you're in active use, that goes to whether you struggle with addiction. He agrees with very much benefit from that.
Is that true, Mr. White? Okay. Okay. Well, do you have a copy of an agreed order?
We just, Mr. Stockton, I do not remember the order, but I can.
Once you tender an agreed order and put little factual things there, so, and let your client sign it also, okay? Little Joe Williams. Commonwealth of Kentucky versus Little Joe Williams. Are you Little Joe Williams? Now look at your affidavit here. I'm going to appoint you public defender, but I'm going to charge you $500. Be paid by the 20th. You're here today for the purpose of arraignment. The grand jury of Monroe County has returned an indictment charging you with reckless driving, failure to signal, operating a motor vehicle under the influence, possession of drug paraphernalia, possession of marijuana, improper use of a red light. Trafficking and a controlled substance in the first degree. Counselor, you now acknowledge the identity of your client. Receive the indictment, waive formal reading, arraignment, interplay not guilty, reserving all pretrial motion. Sign a reciprocal discovery agreement. They're giving you certain information concerning your charges against you. You'll be here for negotiation on October the 7th at 9 a.m. Can you write that date on the back of his card for him there? And here on October 20th, your next court appearance. Both of those are part of your bond. So. Okay, now we go to the court docket. It's scheduled to start at 10:30. Is that correct? Okay, so we'll go off the record right now just for a minute.
transferred to, if they go to KCPC, I wonder if court. No.
Okay, let's go to the jail docket. Is Barron County, you on the line? We don't have any other jail besides Barron. Barron County, are you on the line? There they are over there. There you go. Okay.
Yes, Your Honor.
Okay, we're ready to start. Commonwealth versus Jackie Bowles. 22 CR 0056, Jackie Bowles. Are you Jackie Bowles?
Yes, Your Honor.
You born in 1958?
Yes.
Last four numbers of your social security are 0557. We're here today on a pretrial conference. Y'all have anything to announce?
Your Honor, on Mr. Bowles' case, me and Mr. Stockton had an agreement to continue this until next month. There was also an agreement reached to release Mr. Bowles back onto the district court bond, which I believe was $10,000 at 10% with an ankle monitor.
That's correct, Your Honor, and with a curfew on his bond.
Okay. Well, the standard, we'll set your next, you want him there for the negotiation day?
Yes, Your Honor.
Okay, October the 7th at 9 a.m. and October the 20th are your two court dates, and I'll change the condition of your bond to 10,000, 10% with the normal curfew, go to church, work, or the doctor, okay? Okay, next case is Commonwealth versus David Bridges. Are you David Bridges?
Yes, sir.
Born in 1970?
Yep.
Last four digits, your social security number?
6243.
Okay, this is 22 CR 0064. It says a pretrial conference. What does the Commonwealth have to say?
Your Honor, we were going to continue this for another month for another negotiation day.
Okay, October the 7th at 9 a.m., October the 20th at 9 a.m., both of them conditions of bond. What are the charges in this case that Mr. Bridges that you are proceeding with?
Receiving stolen property, I believe. Mr. Bridges.
No.
Let me have.
Yeah, persistent felony burglary, third degree. I'm sorry, Your Honor, and then persistent felony offender. And Mr. Bridges has more charges coming.
Okay.
Your Honor, I do apologize. Mr. Bridges wanted me to inquire with you about his bond. He recently accepted a probation offer in Barron County with an SSC assessment. That was the intention to send him to long-term treatment. We are hoping that you would consider releasing him to go to a treatment program once it has been arranged and complete that program.
Well, the Commonwealth says he has other charges coming. Mr. Stockton is not here today. Are you saying Mr. Stockton is more familiar with this than you are? Is that what you're saying?
He is more familiar with it, but we would not be in agreement at this time until we can have a look at all of his other new charges coming.
Okay, well, we'll take a look at a bond. Yeah, I'll get together, and if you can't reach in the court, I'll get a date for a bond hearing, okay? See if we can get him in the treatment. At some juncture, you need to wrap all this case is up for Mr. Bridges, so Mr. Bridges can decide what he's facing, what he needs to do, right, Mr. Bridges?
Yes, sir.
Okay, well, y'all kind of get that together and get back with me for Mr. Bridges then, okay? Thank you a lot. Jonathan Brown. Commonwealth versus Jonathan Brown. 21 CR 0011. Are you Jonathan Brown?
Yes, sir.
Okay. Are you born in 1976?
Yes, sir.
Last four digits, social security number is 0306. You're here on a motion for shock probation. Mr. Basil, are you there? Is this your motion?
No, Your Honor, this is the Commonwealth's motion.
Yes, Your Honor. It's our motion to revoke shock probation.
To revoke, it just says shock probation. Oh, a revocation. I see at the end. Okay, I'm sorry. Go ahead, Commonwealth.
I would call Chase Collins.
Okay, Mr. Collins. You want to raise your right hand? You swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Okay, proceed.
State your name for the record.
Chase Collins,
How are you employed?
probation and parole, Department of Correction.
And have you been monitoring Mr. Jonathan Brown?
I'd have on April 21st of this year, Mr. Brown was granted probation for a period of 5 years and started supervision with me.
And what has happened in during your time that you've been monitoring?
On 8/17/2022, Mr. Brown was arrested and charged in Clay County, Tennessee, case number 2020-07416 for evading arrest, reckless endangerment, driving while license revoked, suspended, possession, casual exchange, unlawful drug paraphernalia, resisting stop arrest, reckless endangerment, and evading arrest. Memo from the officer that made the arrest said, I, Deputy Storm Otterson, was traveling down 52 when I met a motorcycle passing a vehicle on double yellow lines in a no passing zone. I activated my emergency equipment, turned around in an attempt to stop the motorcycle. At this time, the motorcycle was passing a semi truck in a no pass zone. The motorcycle continued to pass vehicles at a high rate of speed, putting multiple vehicles in danger. Once I was able to stop the vehicle, I located a bag of marijuana in the person's possession, as well as a pack of rolling papers and a roller of marijuana joint. It was later discovered that Mr. Brown was operating the vehicle on a revoked license. This did occur in Clay County.
Are you familiar with Mr. Brown's original charges?
Yes, it was a theft by unlawful taking or disposition, auto to sale, and traffic control substance, methamphetamine, first degree.
When was he sentenced on that case?
4/21/22.
When was he granted shock probation?
It was that day.
And based on these new charges in Tennessee, does that violate his probation?
Yes,
of his conditions?
yes, it's just
Have those charges in Tennessee been resolved?
Not to my knowledge, Your Honor.
When was he charged with these new charges?
Looks like August 17th of this year.
I don't have any other questions, Your Honor.
Mr. Basil, you have any questions you want to ask the officer?
Yes, I do. Have these charges been to a grand jury or even been in front of a judge yet?
I have no knowledge of any of that in Tennessee going on.
Have you spoken to the arresting officer on this case?
I have not.
But these are charges, not convictions, right?
Yeah, they're charges this time.
Since you have had him on your active supervision calendar, have you had any other issues with Mr. Brown at all?
No, Mr. Brown's reported as directed and even drug tested him, and he's been clean.
And did he test clean after this recent series of events in Tennessee?
He did, yes.
Alleged, you want to say alleged instance in Tennessee?
Yeah, that's correct, Your Honor. Can you tell the judge anything on his background as relates to his work?
I can just tell you from word of mouth what he's told me. What he stated, he had started his barbecue back up in Tennessee and was trying to build that business back up. As far as that's about the only thing I know.
Was that Big Ed's in Bowling Springs?
Yeah, I believe that's correct.
Okay. That's all I have for him, Your Honor. I would like to point out that he is.
Well, it's not time for you to point out anything. I'm gonna have to ask them to, they got any other witnesses? You have any other witnesses?
No other witnesses, Your Honor.
Okay, would you like to call any witnesses, Mr. Basil?
No, Your Honor, I would not. Mr.
Okay. What does the Commonwealth have to say?
Your Honor, just based on these new charges in Tennessee, we would just ask for him to be revoked, his shock probation, especially the seriousness of these charges, even though he hasn't been convicted yet. But just based on the allegations themselves, I would ask for him to be revoked.
Mr. Basil?
Your Honor, he's an employer. He has people that are relying on him. He advised in jail that he felt like he was going to be letting his community down if he was not able to keep this business open. People are relying on him. We're asking that he not be revoked. He's had no other issues. These are not.
Are you representing him in Tennessee on these matters, Mr. Basil?
I am not. I'm
So
not licensed.
Well, you can go down there on occasion and appear with a local lawyer. I didn't know, whether you were down there or not. I'm kind of interested on the resolution of those things down there. Of course, he doesn't have to be convicted down there. I guess he was arrested on a warrant. Was he arrested up here in Kentucky? Was he up here? Or did they arrest him
On a
down
probation
there?
violation. On a probation violation here.
Yeah.
I believe when he reported to his probation officer is when he was arrested.
Okay. All right.
And I think that goes to show that he's not a flight risk or not.
Well, that's not what I'm determining today. I'm not setting a bond,
He showed up knowing that this possibility was here and he came anyway.
Let me talk to the probation officer again, bring him back around.
Yes, sir.
What's your advice on this thing?
Your Honor, I just, only thing I can say is just the nature of the offense. I mean, Your Honor, he's always reported to me like he's supposed to on that side of the deal. I just, the fleeing and evading and the reckless endangerment and resisting stop arrest, that was always a red flag to me. And,
it is a red flag. The thing that bothers me are when people are out driving under the influence, even if it's on a motorcycle, you could hurt some people, and then the resisting thing.
I wasn't under the influence.
Do you want your client to testify?
If he wants to, Your Honor.
Yeah, I think I'll give him a chance to explain it. Raise your right hand, please. You swear a testimony about to give us the truth, the whole truth, nothing but the truth.
Yes.
State your name, please.
Jonathan Edward Brown.
Okay, go ahead. You want to ask your client a question, Mr. Basil?
Yes, Your Honor. Mr. Brown, can you explain to the judge why there were any charges regarding fleeing or evading police?
I went to town and ordered my meat for my barbecue I was opening up the next week, and I owed some people some money for doing some work, and I dropped down in the edge of Tennessee, not thinking, and I didn't have a helmet on, and the double line that I was passing on, it should have been a passing zone. I mean, it was a very long spot there. And whenever I met the police officer, I didn't know that he was going to turn around and come back. And I went around the semi because I was already moving pretty good. And then whenever I got I looked in my mirror and the officer was on me. Whenever he was on me, he was on me so fast that I was scared to let off. And I went, maybe another 200 yards and let off of it and got stopped. And it's just, I wasn't trying to cause no problem. It was a beautiful day and I was riding.
And you feel like you pulled over within a reasonable time and as soon as it was safe to do so?
Yes,
Did they charge you with DUI?
no, sir.
Okay, you have anything else, Mr. Basil?
That's all I need to ask him because he does have these charges pending.
Is the
Another-
barbecue in down in Tennessee or is it in Kentucky?
It's in Tennessee,
Okay.
Springs, and I just hired a cook, and he wasn't trained in. And I've
Does
let my community
Commonwealth
down.
have any questions?
Yes, Your Honor.
You don't have any questions, Commonwealth doesn't?
I do have some
Okay,
questions,
well,
Your
you
Honor.
may proceed, yeah.
Mr. Brown, do you have a driver's license?
No, apparently I don't. I didn't know that I didn't,
So you're operating a motorcycle without a driver's license that day?
but I did not know that.
Okay, and you passed a semi truck on a no pass?
Yes, ma'am, but it was a very, very, it was just a yellow line. It was safe.
And you didn't slow down until you saw the police officer? Is that what you testified?
No, I mean, I slowed down after I got around the car, or after I got around the semi. But
You were charged with evading arrest, resisting stop arrest.
I did. When I first saw him, I'm sorry. Go ahead.
So with those charges, you feel like you stopped in a reasonable amount of time where he shouldn't have charged you with evading or resisting?
Yes, ma'am.
I don't have any questions, Your Honor.
Okay. When's your court date down in Tennessee?
September the 28th. I haven't got to see counsel for that yet. I've made one phone call and I'm willing. I'll take an ankle monitor, whatever. I just need to get back to work because I'm letting my community down. I started in a nasty divorce.
Okay. All right.
Yeah,
I understand that. Okay. Well, I don't like the charge, but at least she wasn't intoxicated while he was driving the vehicle. Let me take this under advisement and you try to get counsel down in Tennessee. Mr. Basil, I know you're not licensed down there, but why don't you try to talk to your client, see who's going to represent him down there and see how they're looking at the thing down there. I'm going to take it under advisement and I'll bring it back up on October the 20th. If you can fill in the blank, Mr. Basil, a little bit about what they're going to do down in Tennessee and give a little bit more information. And I wouldn't mind hearing from the Tennessee officer either. Tennessee, I know that officer. I think he was originally from Cumberland County. He's a young officer. And so if you can get a hold of him, maybe we'll get him on the Zoom the next month. I'll just take it under advisement, okay?
Sir, may I please have an ankle monitor or
Well,
something?
no, I'm going to let them work with each other. I can't do anything down here from the officer, okay? Okay. Now, and Mr. Basil, contact the Commonwealth to see what their position is on any kind of monitor or anything until I get testimony from the officer. Because with the charges the way they are, I don't know. If y'all can interview the officer and get the officer to talk to Commonwealth here and explain a little bit more in detail. Okay. Thank you very much. Wendy Buckner.
Thank you, Your Honor.
Wendy Buckner for arraignment. Commonwealth versus Wendy Buckner. You have an attorney, Ms. Buckner?
I have a Ken Garrett, I believe, is the one I was appointed originally. But as far as indicted.
Mr. Garrett, is Mr. Garrett back there or did he leave?
I'm here, Judge.
You represent this person here?
I do not, Judge. I've not been appointed for about 10 or 15 years.
Oh, maybe it wasn't him. It was Ken. I'm not sure what his last name was. There's someone, I was appointing someone originally when I was charged.
Office of Public Advocacy?
Yes.
You what? Give me the file. Okay, I'm gonna appoint you a public advocate. You are Wendy Buckner. What's your year of birth?
5179
What are the last four digits of your social security number?
5394.
And here for purpose of arraignment, you have the right to remain silent. The grand jury of Monroe County's returned indictment charging you with assault in the second degree, arson in the third degree, being a persistent felony offender on both of those charges. I'm sending the indictment back to you, counsel. Do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, interplay not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, October the 7th is the negotiation day on this case at 9 a.m. October the 20th is the next pretrial. Okay.
Thank you, Your Honor.
Thank you very much. Matthew Burkhead. Matthew Burkhead. Commonwealth versus Matthew Burkhead. 21 CR 00110. Are you Matthew Burkhead?
Yes, sir.
Born in 1993.
Yes, sir.
Last four digits, social security number 6665.
Yes, sir.
You're down on a pretrial conference. What do you have, counsel? What does the Commonwealth have?
We have a felony plea, Your Honor.
Okay. Motion has been tendered, Mr. Burkhead, that says you wish to enter plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No.
Is plea freely and voluntarily given? Are you the same person named in indictment number 21 CR 00110? Is your judgment impaired today in any way? Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
You have certain rights under the Kentucky and United States Constitution. You do not have to enter a guilty plea today. Before I can accept a guilty plea, I need to know that you fully understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. Prior to accepting the recommendation, I will wait a pre-sentence investigation report to be done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, I'll give you an opportunity to agree with that, or you can withdraw your plea and go to trial. What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a firearm by a convicted felon, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to possession of a handgun by a convicted felon, the defendant shall receive a sentence of 10 years. The two 10-year sentences shall run.
Okay, let me
concurrent-
stop you.
Yeah,
Let me stop you. When I was reading it earlier, it says the 2 10-year sentences. And it just should say the 2 sentences. That's what it should say. Isn't that right?
it's 2, 5. Is it 1, 5 and 2, 1, 10?
5, 1, 10.
Yes,
Okay.
15.
5, 1, 10. Yes, it should say the 2 sentences.
Okay.
Yeah, the 2 sentences shall run concurrently for a total of 10 years. Serve 180 days in jail.
Okay, your microphone is off.
Sorry, Your Honor. I'll back up. The 2 sentences shall run concurrently for a total of 10 years. Serve 180 days in jail with the balance probated for 5 years. Probation shall be supervised. The defendant agrees to enter and complete a long-term treatment facility scheduled through DPA. The firearm shall be returned to Tommy Smith if he provides ownership or registration of each gun. Any remaining guns shall be forfeited. The defendant shall pay court costs at the discretion of the court. The defendant shall remain on active supervision until all restitution, if applicable, and fines and court costs are paid in full and further orders of the court. The defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained.
So what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts as charged or as amended in the indictment?
I admitted in the indictment.
Do you plead guilty because you did do the acts that were set out in the indictment or in the indictment as amended or changed? Is this what, did you do these things that you're pleading guilty to?
Yeah.
Okay. Knowing your constitutional rights, I've explained to you, is it still your desire to give up those rights and allow the court to fix your punishment in the range of sentence permitted by law? Okay, you understand that entering a guilty plea, any future convictions that you have of felonies could be enhanced under persistent felony offender law. They'd be more serious. You understand that? Counsel, would you hold the document he signed up to the camera? Is that your signature on there, young man?
Yes, sir.
So I'll accept the plea agreement order pre-sentence investigation report. And probation parole, if you're listening to this, I'm very interested in whose guns these were, the proximity to the guns, the handguns, that sort of thing. I'm a little weary of guns with convicted felons. Things. Okay, well, we'll schedule the sentencing on October the 20th. Okay. James Carter. Commonwealth versus James Carter. Commonwealth versus James Carter. 22 CR 0031. Are you James Carter?
Yes, Your Honor.
Born in 1989.
Yes.
Last 4 digits, social security number 5617.
Yes, Your Honor.
Okay, we're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Okay. What does the Commonwealth have to say?
We're just ready for sentencing, Your Honor.
Okay, counsel, is there any reason why this gentleman should not be sentenced?
Your Honor, we filed a motion yesterday for probation in this case. I have a witness here to testify on James's behalf, and James would like to make a statement as well.
Okay, we'll call a witness, be fine.
Thank you, Your Honor. If I could call Melanie DeWeese.
I believe she's filed a letter also, hadn't she? Did I read a letter?
She did file a letter, Your Honor.
Okay, raise your right hand. Swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
Go ahead.
Ms. DeWeese, can you introduce yourself to the court?
My name is Melanie DeWeese. Mr. Carter is my younger brother.
And Ms. DeWeese, can you testify to anything that has occurred in James' life or the circumstances of his life?
Now, I've read the letter. It's all included in her letter that she's filed with the court, and it's in the record. I'm familiar with that.
Yes, Your Honor. Your Honor, if you would like to consider just the letter, I can go ahead and dismiss Ms. DeWeese. I didn't know.
Well, if there's anything, I'll give her an opportunity to say something. If there's anything that's not in the letter was very well written and in detail.
Ms. DeWeese, do you have anything else to tell the court regarding Mr. Carter or your hopes for the resolution of his case?
Yes, ma'am. Your Honor, one thing that I did, excuse me, leave out of the letter, and thank you for your words. My brother and I have we have different fathers, and his father suffered from addiction. And I do believe that it is genetic. I do believe that the disposition for addiction is genetic. I believe that's what caused him to go down this path. But I do believe that he has learned his lesson. I mean, he is, I think this time spent in jail has really impacted him. I think he sees the impact that is caused on his family and his children. And I do believe that he would benefit from counseling, rehab, some kind of alternative sentence that would be more conducive to his rehabilitation to get him to be a productive member of society once again.
Okay, thank you very much.
Thank you.
You have any other witnesses?
No other witnesses other than James himself, Your Honor.
You want to raise your right hand? Swear a testimony about to give the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
Okay. You may inquire of him.
Thank you, Your Honor. James, can you explain to the court what you have learned from this experience?
For the past 38 days, it's been in the first 38 days I've spent without my son. And the first 15, I slept on the floor. Finally got a bunk. Plain oranges for the first 20 days. I realize there's more to life than what I've done in the past, and I'd like to, be out there to take care of my son and do right.
James, what all do you have motivating you to succeed if Judge Williams was to grant you probation?
My son, first and foremost, second of all, my family. I know I've let them down as not being, best individual in society, but have motivation to move forward with that and do right.
James, you've mentioned your child. Can you explain what role it is that you play in your children's lives?
My son, I'm caregiver. My significant other, she works nights, so I'm constantly at home with my son from sun up to sundown. I hardly leave unless it's just to go get groceries or milk, diapers, things like that.
How has your incarceration for the last month impacted your children, to your knowledge?
For him, I know it's been hard. I can't say exactly how much it's impacted. I've only got to visit with them twice. Our kiosk has been broke and been down. And I've been able to do visits for the past 3 weeks. It just got up and running yesterday. But I know it's hard on my son, and I know it's hard on my significant other too, having to find childcare and things like that.
And James, if Judge Williams was to grant you probation on this case, are you willing to abide by any and all conditions that he may place on you?
Yes.
I have no further questions. Thank you.
Commonwealth doesn't have any questions, I would assume, right?
No questions, Your Honor.
Okay. Well, I've looked at the letters and listened to the testimony of your sister, and I've seen letters from other individuals. And I've heard your testimony, Mr. Carter, but there's one thing I haven't heard you say, that you accept responsibility for what you did. And all you would have had to have done is to have entered a plea and accept responsibility. The case was clear cut. They had you on film. It was a hand-to-hand buy. And you're worried about your child, but evidently you weren't worried about the child or children that might have used those drugs that you sold to them. This is not just a possession case. This is a trafficking case. And so you chose to go to trial, and now you lost the trial, and Now you want to, that you want to tell me that you'll abide by the conditions of the probation. Well, I know that you'll abide by the conditions of probation there. If you don't, you'll go back to jail again. So I cannot probate you on this case. I don't think you're a bad fella. I mean, you've had some success, academic success. You got a college degree. You've had some other sorts of things. I will consider a motion for shock probation at some juncture, but at some point, I would have liked to have heard you say, I was on drugs. I didn't have any money. I had a habit I had to support. So I sold these drugs to keep my habit. But I don't think that was the case. I think you sold those drugs because you get money for them without consideration to the damage that you do to Monroe County in this area. And I tell you what, this damage is felt by every family. Your family is not the only one that is done. I feel sympathy and sorrow for your family and your children, but there are a lot of other children like your child out there that's being fed drugs by people for money. And that's what you did. And that's the reason I'm not going to probate you. So I'm going to sentence you to 6 years to serve. Thank you very much. Okay, Erica Decker. Commonwealth versus Erica Decker, 20 CR 0067. You're here for sentencing. Are you Erica Decker?
Yes, sir.
You had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes.
Okay, I'm going to ask your attorney if there's any reason that you should not be sentenced today.
Your Honor, we would ask the court to consider probating her at this time. She understands she failed to report in the past. Ms. Decker has made arrangements to have residents within Allen County. We have discussed, and she has the desire to obtain employment if she was to be released. We'd ask the court to consider probating her and perhaps setting a review date 30 days after her release for her to have employment at that time. I think employment would help Ms. Decker to be able to be supervised within the community. And she has a desire to gain employment, to be a productive member of society, and to be independent.
Okay, Ms. Decker was given a pretrial diversion, which was voided on August 18th, 2022. So she's had an ample opportunity not only to avoid incarceration, but to avoid even having a felony conviction, and she chose not to do that. So I'm going to sentence her to 3 years to serve in the case. And if you want to file a motion for shock probation at some juncture, so she can establish, after she serves a considerable amount of time, she can establish what sort of employment, other things she might have as she gets out. I'll consider it at that time. Okay. Thank you very much. Stacy Flippin. Yeah.
Your Honor, we were wanting to pass this one till November.
November to October.
Okay. What does the defense say about this? Are you Stacy Flippin?
Yes, sir.
Were you born in 1964?
Yes, sir.
Last 4 digits, Social Security number 1815.
Yes, sir.
What was does the Commonwealth have some reason you'd like to state on the record?
Yes, Your Honor. He's got more charges coming, and we would like to be able to try to resolve all of these at one time.
Okay, they've been presented to the grand jury sometime today or in the future.
Yes.
So what you're telling me is you believe it would be in Mr. Flippin's advantage to spend this time and then try to roll them all up together in some way. Is that what you're saying?
Yes, Your Honor.
Okay.
Your Honor, I've discussed this with Mr. Flippin. He just had his preliminary hearing on Tuesday. So by the time that he is indicted, he will be at that 60-day mark, and he is agreeable to resetting this to allow to see if there's a global resolution that can be reached.
Okay, we'll reset it. You want to set it for the negotiation day? If there's an indictment returned today, let's set it for the negotiation day, Mr. Flippin, on October 7th, and then the next court date was October 20th. So you can start working with them by then. They'll have all the information together for you by then. Okay.
Thank you.
Okay. Do what? Okay, is surety here that was on the bond? Would you like, he's incarcerated, would you like off the bond? Okay, we'll do that. We'll release the surety off the bond. Jonathan Hale. Jonathan Hale.
Yes.
Commonwealth versus Jonathan Hale, 22 CR 0014. Are you Jonathan Hale?
Yes, sir.
Were you born in 1989?
Yes, sir.
Last four digits of your social security are 9473.
Yes, sir.
Okay. You're represented by counsel. You filed an affidavit in here about your indigency. I find that you are eligible for a public advocate. The grand jury, you have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with possession of controlled substance in the first degree and possession of drug paraphernalia. You understand those charges?
Yes, sir.
Okay, counsel, you acknowledge the identity of your client, proceed the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. We will set this for a pretrial conference on October 7th at 9 a.m. and the next, negotiation rather, on October 7th at 9 a.m. And October 20th will be the next court date. Both of those are conditions of the bond. Okay, thank you very much.
Your Honor, and if we could address Mr. Hale's bond at this time.
Okay, go ahead.
And I'm not sure, I know he has a surety bond, but I don't know if he has an individual that is able to post a surety bond for him. And I apologize, I'm meeting Mr. Hale for the first time today. Mr. Hale, do you have someone that could post that for you?
Well, why don't you talk to Mr. Hale, and since you were just appointed today, if you can, what is the bond at Mr. Hale?
It's a $50,000 surety.
Why is that?
He is a high moderate.
For FTA. Yeah, he has some FTAs going on, and that's the reason the bond is what it is. So you can talk to him about that, where you can talk privately with him and discuss it, and then you can get with the Commonwealth if we think that we've not assessed that properly. Okay. Thank you, Caroline Hall. Commonwealth versus Caroline Hall. 22 CR 00077. Ms. Hall, I have reviewed your financial statement here. Here's that you are eligible for a public advocate to be appointed. You're here with the purpose of arraignment. You have a right to remain silent. Ms. Hall, what are the last four digits of your social security number?
4896.
Okay, and born in 1981, is that right?
Yes,
The grand jury of Monroe County has returned an indictment charging you with theft, unlawful taking or disposition, fleeing or evading in first degree, resisting arrest, reckless driving, disorderly conduct second degree, disregarding a stop sign, failure to signal, operating a motor vehicle under the influence. Do you understand those charges?
Yes, Your Honor.
Okay. Counsel, do you acknowledge the identity of Ms. Hall, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, we'll set her for negotiations on October 7th, and the next court appearance is on October 20th. Both of them the first one is at 9. The second will be scheduled if she's still incarcerated. Okay.
And Your Honor, would the court consider lowering Ms. Hall's bond at this time?
Well, I always considered lowering somebody's bond. You give me a reason why the bond, what is the bond now?
10,000 cash. she was actually released from district court on a 60-day order. There wasn't any issues between that time and the indictment. 25,000 cash to district.
Why was there $25,000 cash?
Probably the nature of the offense, but she doesn't have much criminal history.
The charge offense is,
The fleeing or evading
Yeah.
first.
I've read those. She didn't have any other charges.
No.
Yeah. Say the bond was set there because of fleeing, evading, and resisting arrest and driving under the influence and that sort of thing.
There's a theft of an automobile, it's a secret.
Yeah, C, felony theft of an automobile. I think you need to file a motion for a bond reduction if you want a bond reduction, okay?
Okay, Your Honor.
Okay, thank you.
Judge,
Yeah,
the grand jury's ready and there's one that needs to get to.
okay, I need to take a short break and go call upon the grand jury. I'll be right back. It will take me just a second.
Thank you.
Okay, let's start back up here. Did we do Lloyd Hill? We didn't do Lloyd Hill, did we? Barron County, if you'll click back on. Commonwealth versus Lloyd Hill. Commonwealth versus Lloyd Hill, 20 CR 0076. Are you Lloyd Hill?
Yes, sir.
Mr. Hill, you born in 1966.
Yes, sir.
Last four digits, social security number 3383.
Yes, sir.
Let me have this file. Ms. Hunter, did you file this motion?
I did, Your Honor. This is our motion for shock probation, if the court would allow me to speak.
Go ahead.
Your Honor, this is our motion for shock probation. Mr. Hill is asking the court to shock probate him to an inpatient treatment program, Lifeway Ministries in Owensboro, Kentucky. It is a substance abuse program that would also allow him to take his mental health medications. We're asking the court to consider shock probating him there, as we think that it would aid in rehabilitating Mr. Hill so that he may be supervised within the community.
What does the Commonwealth have to say?
Your Honor, we would oppose any shock probation. Mr. Hill was revoked in June for a DUI that he was charged with in April. He has since entered a guilty plea in Monroe District Court for the DUI. Just to refresh the court's memory, that he had tested positive for methamphetamine, and he almost hit Officer Ty Hammer head on Mill Creek Road, which is not a straight road in this county at all, driving under the influence. And so we would oppose any shock probation.
Yeah, I'm not going to do shock probation for anyone that gets out, drives under influence, and while they're on probation. And the charges that he pled guilty to are not all drug-related charges either. So I'm going to deny the motion, and I'll make findings on it. Okay, thank you very much. Lisa Jackson. Commonwealth versus Lisa Jackson. Are you Lisa Jackson?
Yes, sir.
This is 18 CR 00133 and 19 CR 0052. Were you born in 1988?
Yes.
Last four digits, social security number 9624. Is that right?
Correct.
Okay. Ms. Hunter, did you file a motion for shock probation?
I did, Your Honor. This is our motion for shock probation for Ms. Jackson. She is asking the court to shock probate her into the drug court program, or in the alternative, if the court is not agreeable to that, a long-term treatment program to be found by our social worker. Ms. Jackson had a lengthy period of sobriety previously, but unfortunately relapsed when she had a medical issue and had relapsed on pain medication. We are asking the court to grant her shock probation to drug court, as she does have prospects of maintaining sobriety as she has in the past, and we think that structure of the drug court program would assist her with that.
What does the Commonwealth have to say?
Your Honor, Ms. Jackson has a history of noncompliance, and she's been in NCIC. She has just not complied with any of probation and parole. So we would again just ask for her not to be shock probated at this time.
You got the probation and parole officer there?
I do, Your Honor.
Does he know anything? You know anything about this case, officer?
Yes, Your Honor.
You raise your right hand. Go ahead, testimony about to give us the truth, whole truth, nothing but the truth.
I do, Your Honor.
State your name for the record.
Chase Collins. I'm employed with probation and parole.
Proceed.
Miss, I can off my memory, Miss hold on just a minute. Miss Jackson, she absconded from me for seems like a long period of time. And if I can remember correctly, the sheriff's department tried to arrest her at one time. I can tell you this. So A minute here. So it looks like she absconded from me back in May of 2021. She had some jaw surgery, and she was, I think, supposed to turn herself in. And maybe we released her for the jaw surgery, but she absconded after that. I think we had sent her to rehab. She absconded from rehab in Elizabethtown. And then it looks like she left the commitment house, which was another rehabilitation program without permission on 5/22. And then looks like she picked up a felony in Barron County back in March. Let's see, on 6/3 of 2022. She was arrested and charged in 22 M79, which was fleeing, evading, resisting, reckless driving, disregarding a stop sign, and a PFO. And then I think she was just finally picked up on that absconding warrant, Your Honor. She's got quite a few things to sift through here.
There's a pending DUI case that shows up on CourtNet out of Barron County?
She does have pending cases in Barron County, Your Honor.
Well, I'm just not going to be shock probating anybody that's out drunk driving. So if you got a gun, handgun on you, you're out drunk driving, you're going to hurt somebody. Having a gun, being doped up, it's not smart if you're on probation in this circuit. Okay, I'm going to deny that motion. Billy Key. Commonwealth, Kentucky versus Billy Key, 22 CR 0058. Are you Billy Key?
Yes, sir.
You born in 1968.
Yes.
Last four digits, social security number 7694.
Yes, sir.
Mr. Brown, you represent this individual?
Yes, Judge. This is my client.
Y'all reached an agreement?
We have not. I spoke with the Commonwealth about this last week. We're going to need to get the body cam. So we've agreed to reschedule this till next month's court date to get that and review it. I did file a motion to reduce Mr. Key's bond. That should be in the court file.
What is his bond now?
I believe it's a $15,000 surety, and he's been in since April. So he doesn't have anybody to make that for him. And as I detailed in my motion, he's got some serious health issues.
He's got a hold from Allen County too, doesn't he?
I got a bond down there.
I know he has a pending possession case in Allen County.
Trafficking. It's a trafficking case in Allen County.
I believe, Your Honor, he was out on Allen County's bond whenever he committed this new offense.
Well, you can negotiate with him. I'm not going to change the bond right now. You want a negotiation date on the 7th in this case? Commonwealth want one on the 7th.
Yes, Your Honor.
And then a new court date on the 20th. And you need to get that information. What all do you want from him, Mr. Brown?
There's a body cam video of the arrest.
Okay, you need to get that soon enough so he can get it over there where Mr. Keaton.
We have, Your Honor.
Okay.
We mailed it on the 9th, so you should
Okay.
receive
Well, they'll be over to see you so you can see that, Mr. Key. Okay. Thank you a lot. Zachary Law. Commonwealth versus Zachary Law. Are you Zachary Law?
Yep.
This is 21 CR 0022. Mr. Law, were you born in 1997? And last four digits, your social security number 2596. You're here for a pretrial conference here today. Office of Public Advocacy represents you. What does the Commonwealth have to say about Mr. Zachary Law's case?
We have a misdemeanor plea, Your Honor.
Mr. Law, a motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you under the influence of drugs or alcohol? Is this plea freely and voluntarily entered? Is it freely and voluntarily entered? Mr. Law, can you hear me?
Yes, sir.
Is this free and voluntarily entered?
Yes.
Well, I mean, I'm saying, are you doing this? Nobody's forcing you or threatening you to do this. You're doing it because you want to. Is that right?
Yes.
Okay. Are you satisfied with the advice of your attorney, and have you had plenty of time to talk to her?
Yes.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have not right to not testify against yourself. No one can make you say anything. You have a right to be represented at counsel at a jury trial. You have a right to speedy trial. You have a right to confront and cross-examine all witnesses called to testify against you, to produce evidence, to call witness in your favor, to appeal this matter to a higher court if you lose. And you have a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering the plea of guilty today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I don't have to accept the recommendation. This is a misdemeanor case, so I will not order a pre-sentence investigation report. But I'm going to listen very carefully to see if this is what you agree to, Mr. Law. Will the Commonwealth read the offer?
Yes, Your Honor. Upon a plea of guilty to possession of drug paraphernalia, the defendant shall receive a sentence of 11 months to serve. At the entry of this plea, the defendant will have served his sentence, and he shall receive credit for his time served. The defendant shall be released upon entry of this plea. The defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all evidence in the above style case disposed of in accordance with the laws of the Commonwealth and the holding agency. It is understood that this offer is made by the Commonwealth and is not binding upon the Commonwealth until signed by its attorney.
Cost is $210.50. I'll allow you to pay that at $30 a month, starting 30 days from today. I'm going to go ahead and accept the plea agreement. That's what you agreed to. Is that correct?
Yes.
Okay. Okay, knowing your constitutional rights, I've explained it's still your desire to give up those rights and allow me to sign the judgment fixing the punishment on this misdemeanor that you agreed to. Will you hold the signature up there and let him identify it? Is that your signature, sir?
Yes.
Okay, I'll accept it and enter the judgment today, and we ought to get the papers over there. You still, is he served all the time? There's no probation or anything, is that correct?
No probation, Your Honor.
Okay. Okay, when the papers can get over there, you can walk free, okay? Jason Lentz. Come versus Jason Lentz, 21 CR 0045. Are you Jason Lentz?
Yes, sir.
Born in 1975.
Yes.
Last four digits are Social Security number 2675.
Correct.
And this is 00044. What do we have a diversion revocation? What does the Commonwealth have to say?
Your Honor, this is our motion to revoke and to impose sentence.
Go ahead.
I would call Chase Collins.
Okay, Mr. Collins, you raise your right hand. Swear the testimony you're about to give is the truth, whole truth, and nothing but the truth.
I do, Your Honor.
Go ahead.
State your name for the record.
Chase Collins, I'm with probation and parole.
Are you familiar with Mr. Jason Lentz?
I am. Mr. Lentz was on 8/19 of 2021. Mr. Lentz was sentenced to looks like a probation for flagrant non-support. On 8/20 of 2021, Mr. Lentz met with me. General conditions were signed, and at that time, he was given a next report day of 8/25 of 2021. Mr. Lentz explained that he did not know his phone number, but would call me back with a number. Mr. Lentz never called or never gave me his number. On 8/25, which is next scheduled report day, he never reported as directed. On 9/8 of 2021, I spoke with Deputy David Lunds of the Monroe County Sheriff's Department in regards to Mr. Lentz. As a courtesy, Deputy Lunds attempted to make contact with Mr. Lentz at the given address. He stated that he was very positive Mr. Lentz was in the home, and when he done the home visit, he stated that Mr. Lentz, he was positive he was there, but he never would answer the door. He stated he knew he was in the home because He talked to an individual that had just dropped him off minutes prior to Mr. Lunn's arriving at the home. I had Deputy Luns leave a note on the front door, on the knob of the front door. The note stated to call Officer Chase Collins of probation and parole no later than 9/10 of 2021 before 12 noon. And I also provided a phone number. Mr. Lentz never made contact with me in any way.
So just to reiterate, when was the last time that you had spoken to Mr. Lentz?
It looks like supervision began on 8/19. I spoke with him on 8/20, and that's the last time I spoke with him.
So of 2021?
Of 2021.
And are you aware of if he's made any child support payments at all?
I'm not.
Okay. I have no other questions, Your Honor.
Ms. Hunter?
Mr. Collins, Mr. Lentz has not received any new criminal charges during this time, correct?
Not to my knowledge. I don't know.
Judge, I have no further questions.
Are you saying he was gone out of supervision for over a year?
Yes.
Yes, Your Honor.
Okay. Okay. You want to make an argument, Ms. Hunter?
I would, Your Honor. Your Honor, we understand that Mr. Lentz should have reported. We're asking the court to grant him a sanction. And then following that sanction, 30 days after his release, to have a court date to review if he has gained employment and set up a wage assignment. That way, that his arrears are being paid. We're asking the court to consider that. We understand that he made a mistake and there must be a punishment. And that's why we're asking for a sanction followed by a very short period of time that he must gain employment to pay his child support.
Commonwealth have anything to say?
Your Honor, Mr. Lentz has had an entire year to come forward and start being compliant with probation and parole. And if he hadn't been picked up this time, there's a good chance that he still wouldn't be.
Mr. Lentz is not a good risk to put out. He had an opportunity not to be a convicted felon, pay his child support, to live up to his obligations. He lied to the probation and parole officer and he absconded. So I'm going to schedule a pre-sentence investigation report, and we'll have a sentencing on October the 20th. It looks like October 20th. Okay. Thank you. Carrie Likens. Commonwealth versus Carrie Likens. 19 CR 00103. Are you Carrie Likens?
Yes, sir.
Were you born in 1963, as I said?
Yes, sir.
Last four digits, your social security number is 0959.
Yes, sir.
Here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, we have a plea.
Is it a felony plea, diversion? What is it?
It's a felony plea, Your Honor.
Okay. Mr. Likens, I've just been informed by the Commonwealth that you filed a motion for agreement with them that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment 19 CR 00103?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
We had plenty of time to discuss this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
I believe you've been fully informed about your case.
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution before I can accept that plea.
Yes, sir.
I need to know that you understand those rights. I'm going to go over those right now, and if you can't, you don't understand them, you can stop and I'll explain them to you. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, call witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. Now,
Yes,
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, sir, I want you to listen very carefully as the Commonwealth reads out loud the recommendation they made to you and they allege you accepted.
Yes, sir.
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, serve 60 days in jail with the balance probated for 5 years supervised. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substances first offense, aggravating circumstances, the defendant shall pay a $200 fine and cost of $190. Upon a plea of guilty to motor vehicle insurance to be in paper or electronic format, the defendant shall pay a fine of $500. The defendant shall be referred to the social service clinician and follow any and all recommendations thereof. The defendant shall pay restitution in the amount of $263 for extradition transportation costs in 2 monthly payments of $131.50 payable to Monroe Circuit Court Clerk. Restitution is subject to a 5% clerk's fee, and first payment is due within 45 days of being released from incarceration and due on the same date of the subsequent month. The defendant shall receive credit for time served, shall pay court costs at the discretion of the court, shall remain on active supervision until all restitution, fines, and court costs are paid in full and further orders of the court, shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. And the defendant will agree to have any and all contraband, drug paraphernalia, and fraudulent social security cards, have any contraband or drug paraphernalia disposed of in accordance with laws of the Commonwealth or the holding agency.
So what you agreed to, sir?
Yes, sir.
What are the court costs in this case with UI fees and everything together? 615 in addition to the restitution order over there. So I'll announce at your sentencing how we'll space that out for you when we add those two together. Okay. So this is what you agreed to. Are you pleading guilty because you are guilty of the charges in the indictment as amended?
Yes, sir.
Okay. Knowing your constitutional rights, it is still your desire to give up those rights, enter a plea of guilty, allow the court to fix your punishment.
Yes, sir.
Okay, you understand by entering a guilty plea on the felony that could be used against you in the future if you have another felony. And on the DUI, will stay on your record for a considerable amount of time. You can be enhanced on any additional DUIs and could even ultimately be a felony if you get enough DUIs. You understand that?
Yes, sir.
Okay, you hold the agreement up there. Is that your signature on there, sir?
Yes, sir.
I'll accept the agreement, order pre-sentence investigation report, and send you on October the 20th. Okay. Thank you.
Thank you.
It's Brian McHugh next. Brian McHugh. Commonwealth versus Brian McHugh. 21 CR 0064. Mr. McHugh, you born in 1969.
Yes, sir.
Last 4 digits, social security number 5121.
Yes, sir.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Is it substantially correct?
Yes.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor, we would just ask that the plea agreement be followed.
Upon the plea of guilty to failure to maintain insurance on a motor vehicle, the defendant shall pay a fine of $500 in costs. Upon plea of guilty to trafficking controlled substance first degree, first offense, he shall receive a sentence of 6 years, probated for 5 years supervised.
Your Honor, I have proof of my insurance right here from State Farm. I've got a number you can call. You're supposed to have a copy sent to them.
Okay, well, if you'll send a copy over there to your attorney.
She should have one.
Well, let me finish. It doesn't matter whether she has it today or not. I'll take care of it for you if you got it, okay?
Okay.
Just make sure she has a copy of it and the Commonwealth will do an agreed order and I'll amend the judgment on that if it's an order, okay?
Yes, sir.
Was there a treatment provision in here, the Commonwealth?
Let me grab the plea, Your Honor.
Yeah.
I believe so, Your Honor.
That's what I'm reading here. Says defendant shall enter and complete a short-term treatment facility scheduled through DPA. The defendant shall serve a minimum of 90 days in jail. I don't know whether that means in the treatment facility or I can't really
In addition.
tell.
In addition to going, it's in addition to going to treatment. He'll serve 90 days and then go to treatment.
Okay. Do y'all have the treatment place lined up?
Your Honor, we do not as of yet have the treatment program lined up. We are still waiting to hear back about Mr. McHugh's parole or shock probation filed in the Barron County case. I believe his parole eligibility is now October the 1st. So we're hopeful that we will know soon when we can get him in.
Insurance reflects a different vehicle and that the Commonwealth will not be in agreement with me.
Okay, well, we've gotten did you receive that information just now? Okay, I guess the victim's advocate or someone just texted us and said that the insurance document was on a different vehicle. So y'all just need to work through that, see what the deal is. So I guess the 90 days in jail starts today if I sign the judgment. Is that what the Commonwealth thinks?
Well,
Credit. That's not it.
but I received some credit from certain. He will receive any credit for any time that he served, including whatever he's going to get. He just has to serve a minimum of 90 days. So any time that he's already served goes towards that 90 days.
Well, that's what I want to make sure, that's why the way it's written.
Yeah.
How many days has he been in over 90 days? Seems like he's been on the docket for a year.
Yeah. Hey, on this insurance here.
Wait a second. Let me get this other thing. Okay, the agreement was he shall remain incarcerated until the morning he enters treatment. So he's already got his 90 days in. He already had 93 days in. Okay, so you don't have, so the morning he gets into treatment, I'll sign a release order and go to treatment. Okay, now as far as the thing on the insurance, you'll need to talk to your attorney and try to hash that out. I can't have time to read it right now. Okay?
Yes, sir.
Okay, thank you very much. James Mercer. Commonwealth versus James Mercer. 18 CR 00124. Are you James Mercer?
Yes, Your Honor.
Okay, your year of birth is 2000.
Yes, sir.
Last four digits of social security number are 0177.
Your Honor. Yes, sir.
Okay, this says a shock probation revocation. Johnny Bell previously represented you, is that right?
Yes, Your Honor.
I don't see him on here.
I think we discussed, I talked to him. They said something about reckon he was supposed to represent me, but we, conclusion that we wasn't gonna try to fight this. We had to let the revocation hearing go through and revoke, so I can get this over with.
So you're
Wait.
saying you, well,
Yeah.
so you're saying that you want to stipulate to the violation? Is that what, that you,
Yeah, it's fine.
violated shock probation?
Yeah.
He doesn't have counsel there. How's the Commonwealth feel about that?
I'd rather him have counsel where he stipulates.
Why don't you have someone from your office get Mr. Bell on the phone? And we'll get Mr. Bell on here with you and try to accommodate you today, okay? Rather than
All
later.
right.
If you try somebody try to get Mr. Bell on the phone. Jacob Newberry. Commonwealth versus Jacob Newberry. Mr. Newberry still there? Did he picked up by Tennessee yesterday?
He went to Tennessee on the 13th, Your Honor.
Yeah. Well, I wish we'd arraigned him before he left, but that's okay. I guess we'll get another shot at him sometime. Thank you.
Thank you, Your Honor.
Cammy Nafong. Commonwealth versus Cammy Nafong, 21 CR 00115. Are you Cammy Nafong?
Yes, sir.
Born in 2000.
Yes, sir.
Last four digits, social security number 8654.
Yes, sir.
I'm here for pretrial conference. You have an agreement in this case?
You do, Your Honor.
Is it a felony plea or a diversion?
It's a felony. It's a diversion.
A diversion, okay. Mr. Fong, a motion has been tendered that says you wish to enter a plea today. Is that correct? Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 21 CR 00115? You are, correct?
Yes, Your Honor.
Okay. Have you had plenty of time to discuss this matter with your attorney and you feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. Listen very carefully. At the end, I'm going to ask you if you understand them. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to acquire the Commonwealth, prove beyond a reasonable doubt that you are guilty of the charges against you. You understand that being in a guilty plea today, you give up all those rights. And I may consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. In the event that I do not accept the recommendation of the Commonwealth and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Now, I'm going to ask you a couple of questions. Have you previously been diverted in a case during the last 5 years?
I don't know what that is.
Have you entered into a pretrial diversion in the last 5 years?
No, sir.
Okay. Have you had any felony convictions in the last 10 years?
The only charge that I've had has been with drug paraphernalia.
She has no prior felony convictions, Your Honor.
Okay. Are you currently on so you're not currently on probation or anything?
No,
correct?
sir.
Okay. You understand that if you fully complete the diversion program, the charges will be dismissed, pretrial diversion, you have your record expunged. Do you understand that?
Yes, sir.
You understand, however, if you don't successfully complete the diversion program, you'll be brought back into court and scheduled here a sentence hearing. and you'd be revoked in that situation, you would be a convicted felon, and your sentences would be enhanced in the future if you have any other felonies. Do you understand that?
Yes, sir.
What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years, supervised. The defendant shall enter and complete the Monroe County Drug Court Program, shall pay a fine and court costs at the discretion of the court, shall remain on active supervision until all restitution, if applicable, fines and court costs are paid in full, and further orders of the court. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all contraband or drug paraphernalia disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that what you agreed to, young lady?
Yes, sir.
What is the court cost? Court cost is $240. I'll let you pay that $30 a month, first payment, 30 days after you get out of jail. Knowing your constitutional rights, I've explained it to you, is it still your desire to give up those rights, enter this plea and enter into this diversion program? Will you hold her signature up there to the camera? Okay, that needs to be dated. Who hasn't signed that above there?
Your Honor, I believe I need the Commonwealth signature on that. I can get that before turning it into the clerks.
Okay. Okay, well, I'll accept the pretrial diversion and enter it today. Now, does she have time to serve yet, or is she going to be able to get out? And says she's been assessed by the drug court.
Your Honor, I don't believe she's been assessed by drug
So
court.
she'll have to stay in jail. Somebody needs to notify the drug court to assess her and the voter. So it could be several more days, because I guess they met today and they won't meet for a little while. So we'll get that in the works, young lady, and see if we can get you voted on by the drug court, assessed and that sort of thing. Okay, thank you very much.
I have a question.
Okay.
I also asked her if I didn't give the drug court, if there's a possibility that I could do long-term rehab.
Instead of the drug court, you're saying?
Yes, sir.
Well, you need, Miss Hunter, you need to turn your microphone back on.
The only way she thinks she gets the kids back.
You're not Miss Hunter, but you need to turn Miss Hunter's
Yes, sir.
microphone back on.
Your Honor, the offer as it was that she was to do drug court. I've already discussed the possibility of her doing long-term rehab instead with Ms. Anderson this morning. They are wanting her to go ahead and get assessed if she's not going to qualify for drug court due to transportation issues.
Well, okay, we'll just, I'll let the assessment go on. And then if there needs to be a modification order to get her in long-term treatments to the drug court, I'll take a look at it, okay?
All right, thank you.
Okay, thank you. Anthony Rainey. Anthony Rainey. Commonwealth versus Anthony Rainey. 20 CR 0074. Are you Anthony Rainey?
Yes, sir.
Were you born in 1964?
Yes, sir.
Last 4 digits of social security number are 7943.
Yes, sir.
Okay. You're here on a day for motion for shock probation in 20 CR 00074. Ms. Hunter, did you file this motion for shock probation?
I did, Your Honor.
Can you tell us something about it?
Your Honor, Mr. Rainey is asking the court to shock probate him. He has been in custody for a little bit of time at this time. He is asking the court.
How long have you been in custody?
Looking, Your Honor.
16 days, sir.
We're asking the court to consider shock probating him. He believes that he has learned from that time in custody, which is quite a bit of time in custody, that he has to comply with the rules associated with supervision, and is asking the court to give him another shot at shock probation at this time.
What does the Commonwealth have to say?
Your Honor, we would oppose any shock probation. He was granted diversion in February. He went to a 30-day treatment facility, and then after that, he absconded. And he even lied about being in a halfway house to probation and parole. So we just ask that, him not be shocked.
You just got 3 years. You're right. I think he'd probably be parole eligible pretty soon. So considering that he had the opportunity previously, he didn't take advantage of, was not truthful with those other entities, I'm going to deny the motion for shock probation. Okay, let's go to Dylan Russell. Dylan Russell. Commonwealth versus Dylan Russell. Dylan Russell there.
He walked out long ago, I don't know why. I need Dylan Russell. Dylan Russell. Let's add done yet. They're getting him back, Your Honor. I'm sorry.
Okay. Let's do German Serrano. Commonwealth versus German Serrano, 22 CR 0059. You're here today for sentencing. Have you had are you German Serrano?
Yes, sir.
Born in 1974.
That one and only.
Last 4 digits of your social security number, 8896.
Yes, sir.
You're here on sentencing on 22 CR 0059. Have you looked at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason why this gentleman should not be sentenced? Counsel?
No.
Okay. Upon plea of guilty to operating a motor vehicle, alcohol concentration of 0.08 or under the influence, he shall receive a sentence of 1 year to serve. The 1 year shall run consecutively to Monroe Indictment number 21 CR 0029. Probation is opposed by the Commonwealth as well as sharp probation. He shall pay a fine and court costs in the amount of $665. Be paid that at $40 a month, starting 30 days after his release. Okay. Okay, thank you very much. Terry Strode. This is a sentencing. Commonwealth versus Terry Strode. 22 CR 0032. You are Terry Strode.
Yes, sir.
You're born in 1972.
Yes.
And the last 4 digits, your social security number 3139.
Yes, sir.
Okay, there are 2 things here. There's a motion to forfeit. Will the Commonwealth talk about the motion to forfeit right now? What is that? Is there a motion to forfeit on today?
Oh, I don't believe so.
I don't think so.
I don't think so, Your Honor.
Except for the money.
Let me check.
Okay, well, I'll go ahead with the sentencing. Have you had you said your counsel, Mr. Poindexter is on the line now. Mr. Poindexter, have you reviewed this pre-sentence investigation report with your client?
I have, Your Honor.
Okay, is there any reason that sentencing should not proceed?
No, Your Honor. There are some corrections and deletions regarding family history that I'll talk to probation parole about, but that's the only errors that I saw.
Nothing substantial other than those, correct?
Correct.
Okay, well, the jury found you guilty, Mr. Strode, and sentenced you to 20 years. The jury found 3 years to serve concurrently with the 20 and charged 2 for a total of 20 years. So I'll sentence you to 20 years to serve, and you'll get appropriate jail credit on the charges, okay? What is it? You filed a response to the forfeiture motion, Mr. Poindexter.
I did, Your Honor, and attached an exhibit that shows where that money came from, that it was an insurance proceeds and not the result of any type of drug activity. So we're asking that it be refunded back to my client.
Your Honor, I don't have the motion in front of me that Mr. Stockton filed, but if it's referring to the money that was taken from there was no proof that was put on at all that it was insurance money.
Yes, there was a receipt the day of the trial, and it was still in the bank envelope.
I believe there was proof put on. I don't know whether the credibility of the proof or not, but I thought it was pretty good proof. But now, wasn't there a marked bill there too, in with the other stuff?
Yes, Your Honor.
That was separate in my wallet.
Well, I haven't had I'm gonna I'll take that under advisement. You need to present a little bit more on the forfeiture than you got right now in the response. But I think that the defendant Mr. Stroh was correct that there was testimony where that came from. And it was,
we had a receipt.
Wait, I know. I remember it. Okay. So, of where it came from. So, I don't know. I think, I almost think I'll give you an opportunity to supplement your motion by any kind of information that you feel like that was there at the trial, or if you want an additional hearing. But I'm not going to forfeit it now. I think that they put an issue up onto that, so I'll take that forfeiture under advisement. I'm not going to do that this time. Okay.
Thank you.
Okay. Thank you very much, Joanne.
Thank you, Your Honor.
Yeah, Joanne Tooley. Commonwealth of Kentucky versus Joanne Tooley. Yes.
Yes.
This is 20 CR 00010 Commonwealth versus Joanne Tooley. Miss Tooley, you were born in 1963.
Yeah.
Last four digits of social security number 5703.
Yeah.
This says all it says on here is a motion to release what, Mr. Garrett?
This was our motion, Your Honor, I believe. I'm sorry, Mr. Garrett. It was our motion to return the victim's items to the victim's family.
We don't
object. Yeah, and we already tendered an order under Mr. Forrest.
Okay.
It's the same.
Okay, no problem. I'll go ahead and sign it. Thank you. Shasta Vaughn. Commonwealth versus Shasta Vaughn. 22 CR 00055. Are you Shasta Vaughn?
Yes, sir.
Born in 1987.
Yes, sir.
Last four digits, social security number 3221. Is that correct?
Correct.
You're here on 22 CR 0055, a pretrial conference. You have anything, Mr. Garrett?
Judge, we do not have an agreement on this case.
Have you negotiated the case?
We have, Judge. If the court would give us another 30 days, we'd be welcome to do that. She does have two related matters as a result of this case in Barron and F counties. I believe we might be able to get this case resolved. We had a little more time, although I know the Commonwealth wants to go ahead and set it for trial, but whatever the pleasure of the court is, I think it would resolve.
Well, I don't see how the Commonwealth is prejudicing him because he's in jail.
Yes, Your Honor.
You know, how's the Commonwealth feel about this? What's the charge that you desire to try her on, Sanderson?
I believe, Your Honor, she's charged with fleeing and evading, attempted murder, and wanton endangerment.
Other than that,
And a whole lot of other charges along with those. Those were the big ones.
What's the bond in this case? 100,000 cash, so she's probably going to be there for a while. You want to set up for negotiation day?
Yes, Judge.
I'll set up for the negotiation day on the 7th, and she'll be back here on the 20th. And they'll either enter a plea on the 20th, or we'll set a jury trial. This will not delay the trial any, because we will have set the trial out farther than the 20th. So you can expect a pretty quick trial date if there is no plea. Okay. Thank you very much.
Thank you.
Sonny Voorhees. That file. Commonwealth of Kentucky versus Sonny Voorhees Jr., 22 CR 0074. Are you Sonny Voorhees Jr.?
Yes, sir.
Born in 1974. The last four digits of your social security number are 8685. Is that correct? You're represented by counsel here, it looks like. Mr. Poindexter, are you involved in this case?
I am, Your Honor.
Okay, the grand jury, you have a right to remain silent. The grand jury of Monroe County's returned an indictment charging you with tampering with physical evidence, trafficking controlled substance in the first degree, trafficking controlled substance second degree, possession of controlled substance in the first degree, trafficking in marijuana, possession of controlled substance not in the original container, possession of drug paraphernalia, operating a motor vehicle while under the influence, failure to maintain insurance, failure to signal, possession of marijuana, being persistent felony offenders as far as the tampering, trafficking, and in controlled substance first degree and trafficking controlled substance first degree second offense. You understand those charges, sir?
Yes, sir.
Okay. Mr. Poindexter, we're going to lay it on the table out here. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, interplay of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, we have a negotiation day on the 7th and then on the 20th. How long have you been involved in this case, Mr. Poindexter? Will you be ready to negotiate by the 7th?
Yes, Your Honor.
Okay, so you'll be here on the 7th and on the 20th. Okay, thank you very much.
Yes, sir. May we address his bond, Your Honor?
Okay, go ahead.
Your Honor, he was put in an inpatient drug treatment program back in April and has been there consistently until he turned himself in on this indictment. We have filed a letter from the treatment program saying that he is doing excellent and he's getting ready to move up to the next level.
Well, you'll need to have an agreement with the Commonwealth before I'll do that. Consider the nature of the charges.
I spoke to Mr. Hunley today and he said he would have no objection.
Well, he's got another charge in Warren County promoting contraband. Is that right?
Not that I'm aware of. Your
Barron County.
Probably from this charge, Your Honor. What it was, the Tompkinsville police arrested him, transported him to the jail, and he was found with drugs at the jail in Barron County, but
That's
charged it.
That's not good.
I understand that, Your Honor. We would ask that he be released on the district court bond in this case, and then we'll deal with Barron County up there.
What does the Commonwealth
Hunley,
say?
Mr. Hunley said no objection.
How many DUIs is this? Is this a DUI first?
I think it's a second, but I'm not positive, Your Honor.
I'll agree to go with the district court bond with an ankle bracelet.
Yes, sir.
Okay, so he'll get an ankle bracelet on today or when he gets out. What was the district court bond? I'm not going to go with an ROR. District court was an ROR. No.
Okay. What about a surety bond signed by his mother?
$25,000 surety bond and an ankle bracelet. Okay.
Yes, sir. Thank you.
Okay. Brian Walker. No, he's not going back to the rehab. No. Brian Walker. He'd be under the same, Mr. Voorhees be under the same curfew requirements and things everybody else is. Brian Walker, 22 CR 0065. Are you Brian Walker?
Yes, Your Honor.
Okay. You born in 1983?
Yes, sir.
Last four digits, social security number 7297.
Yes, Your Honor.
Okay, you're here today on a pretrial conference in 22 CR 0065. Do y'all have an agreement? Okay.
Your Honor, we do not have an agreement on the case. Mr. Walker's case is going to be conflicted out of our office due to our representation of his co-defendant. We have not yet secured counsel for him, so we would ask to put this on for next month to have an attorney present.
Okay, well, what I want you to do is have an attorney present and have them schooled up enough to participate in the negotiation. I'm not going to wait till another month because y'all haven't got conflict counsel for this young man, and then let him come up here and instead of go to the next month and do a negotiation date. That's not fair to him. Okay.
Yes, Your Honor.
So
I
get him an
understand.
attorney, and sir, they'll be over to talk to you, to explain the case to you so they can negotiate on the 7th. Okay. And that way on the 20th, you'll be ready to make your decision on what you want to do.
Sir, can we address my bond? Can we,
What is the bond? What's the bond? Why is that? Okay, well, why is he a moderate?
When arrested on a new offense, while there was another one pending, his prior misdemeanor conviction, prior felony conviction. No FCA. Two PFO first.
Where the charge here? Yeah, we have two PFO charges in this case is the reason the bond is where it is. So you'll have to either have a hearing for a bond reduction or an agreement by the Commonwealth. Okay?
could I ask the Commonwealth?
No, you can't. No, you need to talk to your attorney because you might say something that would incriminate you. You might say something that would incriminate you. Okay?
Yeah, I was just gonna ask for an ankle monitor if that was possible.
No, you're not going to get any changes in the bond until there's a bond reduction here in agreement with the Commonwealth. And you have a right to one. You haven't used it yet. And I'm not going to burn it up by this short I want you to reserve that for you. That's the reason I don't want you to say anything is so you can reserve a motion for bond reduction. Okay. Okay. Melinda Webb. Commonwealth versus Melinda Webb, 22 CR 0068. Are you Melinda Webb? You're here today for the purpose of arraignment in 22 CR 0068. Were you born in 1977? What's the last four digits of your social security number?
001.
Okay. Yeah, I reviewed your affidavit. It appears that you qualify for a public defender, so I'm going to appoint one to you. The grand jury of Monroe County has returned an indictment in 22 CR 0068 and charged you with possession of a controlled substance first degree. You understand that charge? You understand the charge? Are you saying something I can't hear?
Yeah, yes, sir.
Okay. We'll set a negotiation day on the 7th. The 7th of October, and your next court date is October the 20th. What is this lady's bond?
Yeah.
State inmate. Okay. Okay, well, if you resolve your state inmate status, I'll take a look at your bond, okay?
Thank you.
Okay. Edward Whitledge. Commonwealth versus.
Morning, Your Honor.
Hello, Commonwealth versus Edward Whitledge. 20 CR 0085. Are you, Mr. Whitledge, were you born in 1991?
Yes, Your Honor.
Last four digits social security number 9664.
9864.
9864. Okay, that's right. Okay, there's a pretrial conference and a motion to compel. What's the motion to compel about?
Your Honor, I filed a motion for specific discovery, asking for some items we believed were missing. I have been in communication with Mr. Stockton about that, and he's agreed to respond and provide that discovery by the end of the month.
Okay.
So I would just ask the court to give us another date, perhaps in November.
Well, what sort of information is it? Is it?
Your Honor, I had a list. It includes cell phone data, phone records, KSP reports, evidence logs, warrants. There's quite a few things.
Mr. Hundley, how long is it going to take you to comply with that?
I'm not certain that we will ever be able to comply with some of it, Your Honor, because I believe some of it will be in possession of the law enforcement authorities in California, where he was arrested to begin with. Otherwise, we have met and have another meeting scheduled with the detectives in this case. Hopefully, we will get it by the end of the month, but that might.
Well, I'm going to set y'all to come back here on October 20th. I'm not going to set the October 7th negotiation day with everyone else because this is a pretty complex case. So I'll let the two of you try to schedule a negotiation date before October 20th. I'll just leave it up to y'all to do a negotiation date. And then you'll be back here on October 20th and we'll see. I'm all about setting a trial in this case. So, because it's going to still be a little ways out, but I give this case priority over some other cases. Okay.
Yes, Your Honor.
Thank y'all very much. Yeah.
Your Honor, may I approach on an ex parte matter?
Well, not right now, but because I can't get you, I'm right in the middle of a docket, but you can call me and do that about that. If you'll, I guess your phone number is probably on the motion that you filed, isn't it?
Yes, Your Honor, or if I could approach at the conclusion of the docket.
Okay, well, just stay on there. We'll see what we can do if I can get you on, in a side room or something. Okay.
Thank you.
Edward Whitledge. Edward Whitledge.
That's the case we just called, Your Honor.
Edward Whitledge, excuse me. I had that wrong, numbered wrong. I've got another one here somewhere. Oh, Bobby Pruitt. Bobby Pruitt. Commonwealth versus Bobby Pruitt, 22 CR 0015. Mr. Pruitt, were you born in 1983?
Yes, sir, Your Honor.
Last four digits of your social security number are 3486.
Yes, sir, Your Honor.
Looks like there's a probation revocation motion here. What does the Commonwealth have to say about that?
Honor, we were going to pass our motion to next month. He was being assessed.
And Judge, you signed an agreed order to release him on an ankle monitor after he's been assessed on the 13th. Well, yeah, 2 days ago. I don't know if he's been assessed yet, but he should be able to be released to go back to work once that's happened.
What does the Commonwealth have to say?
No issue with that, Your Honor.
Okay, well, if somebody needs to tell me when he's assessed, so does that mean after we receive the report or after the assessment takes?
Your Honor, Mr. Collins is here and he said he has been assessed.
Okay, well, do we have the report?
Yes, Your Honor. He's assessed to attend a long-term treatment program. We request the bed if the court allows, and then we can release him once that bed's available to attend.
Okay. Get him in the bed and I'll sign a release form then, okay?
Yes, Your Honor.
Thank you, Your Honor.
Okay, now we got another one here somewhere. Dylan, there it is, Dylan Russell. Yeah, I lost it there.
Yes, sir.
Commonwealth versus Dylan Russell, 22 CR 009 and 22 CR 0008. Are you Dylan Russell?
Yes, sir.
You born in 1996?
Yes, sir.
Last four digits of social security number 1233.
Yes, sir.
What do we have here? It says it's a pretrial conference.
Your Honor, Mr. Russell was arrested on a bench warrant for failure to appear at negotiation conference. Mr. Stockton, I believe, is wanting to put this on for next month. I believe we'll have a resolution at the time.
Well, there was more than one time that didn't appear. Well, it was two times. Isn't that correct?
Just once, or the other time I had the corona, the COVID-19 virus.
Yeah. Okay. So set a negotiation date on the 7th and the next court date on the 20th.
Hey, sir.
Thank you, Your Honor.
Hey,
Thank you.
I got one quick question. My wife is being induced into labor in 2 weeks. And anything like any kind of furlough or anything I could get on it just to see my baby that day.
What's the charge in this case? There's two cases. Now, I'm not asking you. Okay, I'm asking him, but I'll get back to you. Okay, hold on a second.
Your Honor, one of them is an assault third degree on a police officer, probation officer, and then the other one is burglary third degree.
Well, I think your defense attorney needs to call the Commonwealth. If he doesn't have rabbit blood in him, I wouldn't have an objection for him to be at the hospital at the birth of his child in some way, if we can accomplish that. I'll try to accomplish that. So hopefully you can get this behind you and help raise the child.
Yes, sir. That's what I'm trying to do.
Okay. Well, they'll talk to each other and I'll try to get an order on that. Okay.
Thank you, sir.
Okay. Now, is there anybody else there that we hadn't talked to in the jail?
I just have
Your Honor, on James Mercer, we passed him, tried to get in touch with Johnny Bell, and we have spoke to Johnny Bell, and he said he no longer represents Mr. Mercer.
All right.
Well, Mr. Mercer said that he wanted to stipulate to the violation, and Mr. Mercer, you feel like you're fully informed about the case, and you have discussed this matter with your attorney.
Yeah, I talked to him about it. Yeah. Yes, sir.
I'm going to go ahead and allow him to stipulate that and sign the order. And I guess the officer that's waiting can be excused, and you can do that. I believe you know what's going on now. And if we have anybody we haven't addressed there at the jail, Madam Jailer.
I guess the facts are what
I'm here, Your Honor. What do you need me to do?
Is there anyone there that we haven't called?
Oh, no, sorry.
Okay. This gentleman to your left here, to your left. What's he?
He said he's wanting to ask you a question because he wants to know how he can go to a bed date and have an ankle monitor on or something.
Yeah, they said I could get out on an ankle monitor, something about and wait until I was assessed. I don't know. Can I get out on the ankle bracelet right now and wait for a bed? I don't understand.
Which case was that?
Mr. Brown, Bruce Brown representing, he indicated that there was an agreed order letting him out on an ankle monitor once he had been assessed, but Mr. Collins stated that they were working on a bed date and he would be released on the day he got a bed date. I'm not sure that agreed order was signed. I don't know if it was just tendered to the court.
Okay. Give me his file here. What's his full name? We'll check this here.
Yes, sir.
Is the probation pro officer still in there?
He is, Your Honor.
And what was the deal on this gentleman here?
Your Honor, Mr. Pruitt was arrested, I believe, for assault.
Yeah, but I mean, you've agreed to send him to the long term.
Yes, I emailed the social service clinician just a minute ago, letting her know that court would allow him to go to rehab, and we're just waiting on a bed
So
date.
there's no reason to have an ankle monitor on him if he's going directly to rehab, correct?
I don't think so, Your Honor.
You agree with that? The Commonwealth agree with that?
Yes, if he's going directly to rehab, that's fine.
Okay, see, the deal was, I thought you might have to stay out a day or two before you went to the rehab, but if we're going to wait now and they'll send you directly to rehab. So forget about the ankle monitor, okay?
Thank you.
They'll get you a bed as soon as they can. Okay. Thank y'all very much at Barron County. You may be excused, okay? Okay, does that complete the criminal docket? Okay. Is that on the person docket? Okay, Commonwealth of Kentucky versus Mark Brown. 21 CR 0034. They're going to come in. So, you sit around on this side here. Let me ask
Your
you.
Honor, do you want us to come in?
Yeah, why don't you come in? Yeah, come in. Let him behind the podium is what I'm telling you, just for a second. Are you Mark Brown? You born in 1975? What are the last 4 digits of your social security number? We're here on 21 CR 0034, probation revocation matter. You ought to go over there and take a seat if you want to. The defense table. Yeah. Okay, this is a Mr. Mark Brown. He's already been identified. And this is a probation revocation.
Yes, Your Honor.
Commonwealth want to proceed?
Yes, Your Honor. Mr. Collins. Oh,
She's on the screen up here. Supposed to be. Why is she not on the screen now? On the big screen up here? There she is. Will you raise your right hand, officer? Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth. Okay. Okay.
Yes, sir.
Okay, Mr. Hunley, you want to inquire?
yeah. What is your
You
name?
probably have to get up here to the podium for it to work. Can you see Mr. Hunley?
No,
Can you
Your
hear
Honor.
Say something, Mr.
Good
Hunley.
afternoon.
I heard him say afternoon.
All right. Are you Chastity McCorkle?
Yes, sir.
And by whom are you employed and what is your position?
Probation and parole officer.
Have you been the officer supervising the probation of Mr. Mark Brown?
Yes, sir.
When did that supervision begin?
I'm sorry, did you ask me when his supervision began?
Yes, ma'am.
It began on October 22nd of 2021.
He received a sentence of 7.5 years for the offense of the trafficking in methamphetamine over 2 grams.
Yes, sir.
How many violations over the since you've had him on under your control? How many violations of use of marijuana has he had?
He's had a total of 5 violations for use of marijuana since he began supervision.
Yeah, really, I counted 7.
Well, you're not testifying, though. So. I have a violation from 10/25/21, 1/25/22, 3/16/22, 6/15/22, and 9/1/22.
The last one was 2 weeks ago.
Yes, sir.
And he also had on March 16th, when he denied the use of marijuana, and you had to send that to the laboratory for further testing. Is that correct?
That is correct. Yes, sir.
And the lab results showed not only that it was marijuana, that he was positive for marijuana, but it was diluted.
Yes, sir. That's correct.
I have no further questions.
It doesn't really matter. It'd be, if you speak up, you're gonna have to take your mask off. She can't hear Mr. Hunley. I know she can't hear you. Yes, absolutely.
Officer McCorkle, can you hear me?
Yes, ma'am.
Officer McCorkle, while you have been supervising Mr. Brown, he has not had any new charges, correct?
Correct.
He has maintained employment, correct?
Correct.
He has continued to report to you, correct?
Correct.
And you're going to continue to support his dependents, correct?
Can you repeat that?
To your knowledge, he has continued to support his dependents, correct?
To my knowledge, yes, ma'am.
Runner up no further questions for Officer McCorkle.
We have no further witnesses.
Okay, you may be excused, officer. Thank you for being patient with us, okay? Okay. What does the Commonwealth have to say?
Well, here that the offense is, but it's just marijuana, but it's also just 5, 6, or 7 times, depending on how you look at it. And I understand that from I talked to Ms. Hunter on it, she very eloquently has set forth the proposition that it's just marijuana and that he provides for his back and he works. But Your Honor, please, every time he tested, it's marijuana. According to.
What about the diluted test?
And the diluted test, which showed purpose to deceive. I just don't. If this doesn't qualify and should be proper ground for revocation, then we won't have any.
And come to the podium if you would.
We acknowledge the violations are as they are. I would like to go around to bring the people in terms of mitigation to the court have understanding that his family situation is what we want you to.
I'm not, the family situation is not going to prevail in testimony on that. It's not going to prevail. If he wants to testify about why he's using marijuana in direct contravention of this court's, and I'll let him testify.
Your Honor, I would ask the court to consider giving Mr. Brown a sanction on home incarceration. He has been working his job for 7 years to provide. He has 6 children under the age of 18 that he is providing for.
Why don't you go over there and talk to him and see if he can come back in here and convince me that he's not made a mockery of the terms of his probation and why I shouldn't suspend it. Why don't you go have a talk with him on that?
Brown, those fans that you can, they're going to use the marijuana. Also, raise use in overcoming that addiction. I believe that.
What are his work hours like?
We would ask.
Where does he work?
He works with Rainbow Janitorial Services. He has worked there for 7 years.
Where is that? I didn't say who. Glasgow. Okay, I'm going to give him a sanction. I'm not going to revoke him. I'm going to give him a sanction. I want him to spend the next 5 weekends in jail. He comes in on Friday, gets out on Sunday night. Next 5 weekends. Okay. Goes in at 5 o'clock on Friday. Next 5 weekends. Now I'm telling you something. I'm telling you this. If you violate any terms, I'm giving you this break because you're working. Not many people work come in front of me, okay, and you make some have it. But you cannot just do what you want to do. You cannot be smoking marijuana. You cannot be using illegal drugs. You cannot be doing that. If you want to do that, I will be glad to transfer your probation to Colorado or somewhere where it's legal. It's not legal in Kentucky yet. When it becomes legal in Kentucky, if it ever does, then you can come back in here. But until then, you're not going to ignore this court's orders. You understand me? Okay. Make arrangements with him, with the probation parole officer to lodge him. And the lodging will start tomorrow. Okay, for 5 weekends. Okay, thank you very much. Does that conclude the criminal docket? Let's go off the record then. Yeah. There you go, young lady. Carmen, I'm gonna get you on this. You better die. Now you wanted to do, yeah. Okay. Not on the real PS. 14 CI 0053 Jimmy Evans versus Billy Pickle and others.
Good afternoon, Your Honor.
Hello. You're here for the plaintiff, right?
Yes, Your Honor.
Doesn't look like the other side is here. Y'all get together with your calendars and get 2 days in June, middle of June sometime. Avoid Thursdays. Try to start on Monday or Tuesdays. Okay.
Understood, Your Honor.
And get a hold of my staff lawyer, and we'll put you on the calendar sometime in June. Okay.
Understood, Your Honor. Thank you.
Okay, thank you. Yeah. Jennifer K. Roberts versus Charles Edward Roberts. Hello.
Your Honor, I filed exceptions on behalf of Charles Roberts to the DRC ruling in this case.
Do you have an attorney?
Spit it up on her own, Judge, but DRC is recommending my client go under the sexual offenders treatment program. He was not committed of any kind of not found guilty of any kind of felony sex crime. He pled years ago to a misdemeanor charge, but he is on some form of a registry. I don't really understand that, but he's got a reported address. Other than that, he has no restrictions. His only felony on his record is the flagrant non-support. And I would just ask you to take that out of the rule and graduate with the station.
How old are the children?
7. And she hasn't been here with 3 years.
And now we are part of that's what she just won't let. Every allegation occurred prior to the marriage of this party.
He doesn't pay child support regularly. He's not done any of the getting the certain things to do with the
She got into the parenting thing. You have any testimony? I just guess we'll review it. So now that's the only change you want. What did the commissioner say exactly?
Your Honor, commissioner wanted him to enroll in a sex offender treatment program, and then there'd be some kind of counseling or rehabilitation counseling between my client and his daughter. I would just ask him, he'd be allowed to graduate with it.
What would they, out of an abundance of caution with a little girl? I mean,
I started to see that side of it, Judge. It's my client's position that he had to find a relationship with her until the spouse just left with the child, mutually to the child.
she has had a lot of counseling. She does not want to see him. Nobody said anything, this is just her to do it. And it's not her naturally speaking, it's her telling you about her nightmares and stuff, and when she's listening to her. And she is, usually that child back.
where was it? Where was this conviction or plea at? And what did it involve? What did it involve?
Well, I've been on 15 and 4 years ago. 16.
And if you see in the paper, you say other children speak to that lawyer about what happened to them, that they've had counseling for most of their life about this. They haven't been, but
Where is this counseling available?
Your Honor, I truly don't know. I don't know if we have 2 new local counselings here. I don't know if they do it. One's on Main Street and one's on Third Street. I don't know if they do that type of counseling or not.
Well, I mean, the commissioner just didn't make the counseling up, you know.
So we're having trouble with Judge. I mean, if counseling's ordered, we understand that, but we would need to know where to go and how to go about that.
my issue is that she's safe and she's happy, and that's what he should be concerned about. And paying his child support is part of being a parent that he wants to be.
Well, this is not about child support.
No, it's not.
As a matter of fact, the child support was brought up earlier and they said he's up to date on his child support. But we're not talking about child support. He'll pay his child support.
It doesn't end up, you know, everything else, like all the rest of the
You and every other parent worries about that. But the problem is commissioners evidently seen something in this that has to indicate that he feels like that there ought to be an abundance of caution before someone that's on a sex offender register, even if it's 16 years ago, somebody takes a look at it. And I don't think that's unreasonable. You know, now, if you find out that there's no sort of therapy that you can get like that, then I will allow you to leave the issue open and bring it back to me with some evidence of what sort of things are available. You need to be prepared for that. I'll hold you to the same standard as I will Mr. Carter if you don't have an attorney. But you need to go look and see what kind of therapies would fit this general description that the commissioner said. And if you can't agree on that sort of therapy with each other, I'm gonna let you talk to him, okay? Because I don't know why you don't have an attorney, but I would think about getting one on this issue. It seems like all of it's resolved, but I'm inclined to require some sort of therapy, and we just have to determine what a therapy is appropriate and supervision is appropriate, okay?
Could I ask the court, on the record, I don't know how you want to handle it. I'm pretty sure I'm going to read your phone number off on public record, but if I give them my card, it'd be a verbal order for the call, we can contact.
Yeah, that'd be fine. You can contact him, right?
Sir, I left him.
No, I'm talking about the lawyer.
Yeah, I left him and I stayed hiding for 2 years.
I'm talking about the lawyer. Contact the lawyer. I'm not asking you to give any phone number to anybody. You get somewhere with a block number or whatever and call the lawyer. I'm not asking you to contact him. And as far as you're concerned, if during this contact while we're trying to negotiate this, I can just give somebody 6 months contempt at a time. But the first time out, you get 6 months. If you get around and try to bother this woman or anything. You understand what I'm saying?
Yes.
Okay. I just want to make sure we're sure. I have no reason to believe you will. But I don't want you to be surprised. Okay? Okay. Y'all contact each other and see if you can agree upon what kind of counseling it is. And if you still think that's too burdensome, you can redoct it.
Thank you.
Okay, thank you. Okay. Sherry Butler versus Signature Healthcare. Is this the last thing I'm doing? Hello.
This is our motion that I've seen opposing counsel, and the only thing I received in response was a notice of interference. I think Mr. Mann and Mr. Proctor have left you moment the interference indicated cross man law. So I'm not sure. I think they're probably pretty busy right now, and they just overlooked it. I'm not sure.
What do you want to happen?
This is our motion.
I know.
It's
Take the mask. I can't understand you.
I don't like those things.
Yeah, y'all need to hold down on because you're keying the mic, okay?
You know, this is a lawsuit by the Forest Owner State against, or
yes, this is a case against nursing home, and our position and the purpose of this motion is to seek to enforce an arbitration agreement with this time out as well as power attorney for Mr. Comer. We're asking that the case be stayed or dismissed and the order of compelling arbitration. Typically, the plaintiff has something to say about that. I don't want to, run roughshod over their rights. I'm surprised that they're not here. I don't know.
So this is one of your boilerplate arbitration agreements that people sign when they go into the nursing home. Is that what you're doing? Yeah. How do they hold up under scrutiny? Usually?
Well, if you have a valid power of attorney, usually pretty well. A lot of times there are issues with respect to that. They've done their best to try to give people a period of time to back out on leave and after they sign them and so forth and for a lot of protection. So they're going to put the Federal Arbitration Act and the Uniform Arbitration Act that once we put forth a valid agreement with somebody who's authorized to sign it, that presumes valid and burden shifting situations. So the plaintiff has to come in and demonstrate why.
And who's plaintiff's attorney now?
I don't believe these gentlemen are, but Ross and Michael Roberts, they were even calling that now they're both here with Ross and Ross. Seems involved in that.
Well, why don't you try to contact them and ask them? And you want them to compel them to do what?
Well, we like to have the case into arbitration litigated in that form. We think that's correct.
Well, you give them notice. Just give them notice, a show cause notice. They weren't here today after notice did, and give them a show cause notice to appear on October 20th, while they should not be compelled to pay your costs for attending here and to reschedule it on that date. Okay.
Yeah. And we'd be fine if it is an oversight on their part, Judge.
Well, I didn't say I'd follow through with it. I just said, I mean, you got to do something, get them back on the docket.
I guess what I was I could reach out to the state. I'm sure they want to file a response. We'd like to file a reply and then just allow it to be submitted.
Yeah, and have them here on the 20th, so we can move along. Okay. Okay. Thank you.
Thank you. Might be an Oxford as well.
Yeah. And we got one more case. There's another civil motion there. Okay, well, we don't have anything for 7 minutes then. Okay, we'll go off the record for 7 minutes. Okay, we're back in order. We've been checking the record before we came back on. This is Pitcock versus Pitcock. I entered a temporary, entered an order, but wanted to make sure that the possibility to object to the order, file exceptions was made available to the respondent who was, who responded, but it doesn't appear that's been served on Derek Adam Pitcock. Do we know a correct address on Derek Adam Pitcock? Do you know Derek Adam Pitcock?
41 June Brown.
Well, let's, why don't you prepare something for the sheriff's office to serve? And we'll try to serve him and notice him one more time on October 20th. You'll try to make some effort for the sheriff.
I'm not certain we'll take these in a while.
Well, the first one was supposed to be mailed, and I thought maybe maybe it's an address is still at a father's house.
Yeah, well, we'll try to get him served. What does it cost to serve somebody? The gas doesn't cost that much over here, cheaper over here.
I don't do with the money part, I just.
Yeah. Well, just contact the sheriff's office, have him served.
Lacey bill. They can't find him, I'll do it.
Yeah.
Let Lacey, I'm sure.
Okay, thank you very much.
Renotice for.
The 20th, yeah, and just in the motion to renotice it, just send me an order to renotice it and just say that it previously been noticed for today for him to file any exceptions, but it appears he was not served. And the court directs that he be served by a sheriff to be given one last opportunity to object to those findings and the temporary order should stay in effect. Okay. Okay, thank you very much. Yeah. Are we down to the confidential matter? Okay. Let's go off the record. What did I tell them to do in that case?
Get with everybody, we debated.
Miss Roby, are you on the line?
Yes, sir, I am, and I apologize for being late for your court. I was tied up in another courtroom.
It was more important, obviously, than that. Court.
No, sir, it was not, I assure you.
That's what it sounded like to me, the bailiff. Where are you? And I'll send this bailiff over to visit you.
I'm in Russellville.
Yeah, it's too far. It's
too far to worry with me,
yeah,
Judge.
you looked at, well, I told counsel on the other side to contact you and to get some dates in June. And then I would get back on Zoom and we'd set date certain that was okay for both of you, okay?
Yes, sir, I'll do that. And again, my apologies.
That's all right. That's not the worst disrespect that's been shown to me today, so I can overlook it.
I can only imagine. Have a good day, Judge.
Okay, bye-bye.
Thank you.